Hello and welcome. This is Gray Hughes of Gray Hughes Investigates on YouTube. This channel evaluates all aspects of true crime. As you are aware, videos and live streams in this genre often discuss elements of crime that may be disturbing to some viewers. If necessary, take the precautions needed to avoid these feelings. Factual information related to cases is the key to fostering rational true crime discussions. Fortunately, you will find that here. Please hit the like button only once. Share the video and subscribe if you like my content. Thank you very much for watching.
Come on, man. What's wrong with you?
You know, that's just one step above stupid.
5 brain cells, 4 aren't working. There's mosquitoes the size of bald eagles in that dadgum swamp.
Huh? It's a house! Huh? It's a house! Huh? It's a house!
What's going on, free? All right, well, there's a hearing today in the Tyler Robinson case. Hello, ANAP. You know, not, there wasn't one comment under last night's 4-hour live stream. Not one single. I thought it was pretty damn interesting. We even went over the Roswell stuff regarding, the general that's missing. Can you just go over there and make a comment? Somebody say something? Jesus. Unreal. Well, here's a hearing in the Tyler Robinson case. You know, a hearing that Candace Owens won't be watching because she knows the real truth, everybody. She knows that this was a combination of aliens, the Mossad, Egyptian government, Turning Point USA, etc., all plotting and planning to kill Charlie Kirk, but just not one person in that entire group of people has ever come forward or, let it leak somewhere. Instead of just believing that it was Tyler Robinson, who actually is the killer. I'll say it right now. Tyler Robinson is the killer of Charlie Kirk. Great. That's not cool, dude. It's innocent until proven guilty. That's what the trials are for, but I can tell you right now that Tyler Robinson is the killer. There is no doubt. All right? So just know that. Now, you might want there to be doubt to make it more intriguing for you, but the truth is Tyler Robinson is the killer. All right? Hey, thanks so much there, Paul Ayers. Actually dated somebody one time with that same last name, Ayers. Probably a cousin or something.
I felt like look at you. Utah Jazz.
I didn't turn that off. It's there. I mean, this case is one of the most obvious cases in history. They need to definitely need this to be streamed, etc. No doubt about it. I think that's what today's hearing is. In May, they're having a preliminary hearing, and that is going to be the shit. I can tell you that.
Got all these cases from Tucker.
What did he do again? I don't know what that means. Now we speak English over here. All right. Watching from Poland. Oh yeah, you got. I'm not sure what you're saying. You typed it in Polish.
They are filed on their information. They screen them and file them. So this is,
I do. I think Candace Owens is one of the worst people on the planet Earth. Right?
That is your case.
She is a horrendous person. I've been saying this since the very beginning, before it was sort of, like everybody else started noticing. I was watching just right away, right after Charlie Kirk, and you could see her going. I wonder what Megyn Kelly thinks now.
Yeah.
Because Megyn Kelly was defending Candace Owens, how I didn't hear her attacking Erica.
Yeah.
I didn't see that. Well, we did. We all saw it coming. We could see the wording. It was passive aggressive. And then boom. Now that's all she
You might
does.
have some cleanup. Make a record of the discussion.
I don't know how to decipher what you're typing in that. Is there a way to, anybody know how to translate
One
that stuff?
Applications and stuff like that.
Yeah. Told you he's the most handsome. She didn't believe me.
Let's see. I don't know how to do that. Doesn't have a translation. I think it starts in a few minutes. It said 10, so I actually even on my calendar. But I looked and it said 10 when I looked at the Utah site, so then I was thinking, man, this must be starting like right now. At 9, because it's 9, it's 10 there in Utah, but 9 my time. So I decided to, just out of caution, come on here early.
The meeting, yesterday's morning's meeting.
And thank you, Tony Morrow, as in tomorrow. You get it? Tony Morrow. You know what's weird is Morrow. What's his name on Fox News? He's good. Well, just type it in the best you can in English because nobody can understand it, and there's no way to translate. Hit the translate button. Hey, thank you, Laura de Nima, or Laura. Let's see, Laura. Or they're getting ready to do this.
There's absolutely no recording of any type. If you're media, you have your laptop.
Well, I'll have to work on the fly with the audio. If the audio sucks, I'll have to boost it up quite a bit. So whenever I talk, it'll sound like that. Oh, I did? Oh, wow. I can't remember how I said it the first time. Laura Denima. Is that right? Laura Denima? Laura Dean. Oh, man.
How dare you?
Lorati. Okay, Laura Dean. Okay, I got it. Yeah, Paul Morrow. He's the best on Fox News. He's the absolute best. He's the best crime analyst of every single person that's on social media. He's the best. Just common sense, very. Who loved? What does that mean? Loved Jews maybe, but criticized Israel. Who? Who are you talking about? That's not Candace Owens. She hates Jewish people. That's why she mocks them every single day. Why is that? Yeah. His attorney also is the Corey Richins trial currently. They're in court at 1 p.m. for jury instructions. What do you mean? That case is already going on. Corey Richins. Oh, jury instructions for deliberating. It's over? Is that trial over? Thank God, man. What a boring... I can't even believe people watch that. That thing is so obvious. That was one of the most obvious cases again. I mean, this one, I'm going to cover it because I've been doing it. I guess that's why people want to do it. But it's like Corey Richins, we covered that at the beginning, and then we went over the probable cause, and boy, it's just no evidence. How much you want to bet she'll be found guilty on that? No evidence. Jesus. Oh, they're idiots then. No, it's absolutely proven, yeah. So you guys just don't want to believe it is because it makes it more interesting. Yeah, she 100% did it. Yeah, well, she wouldn't be found guilty if it wasn't proven. You see what I'm saying? See, people just want her to be innocent because it makes it more interesting. You know, it's like, ooh, I'm so edgy because I think she might not have done it. No, you're just your brain malfunctioned. Okay, it's not working correctly. Just read the facts of the case. You got it. Who cares if it wasn't found in the house? Why would she? Okay, you're going to kill somebody with fentanyl and then leave a jug of it sitting around? I mean, you guys are crazy people. You know, you're using the same idiotic logic that the people do in the Idaho 4 case. You know, he didn't do it. He didn't do it. Here's why. Because he didn't have it. There wasn't one shred of blood or anything in his car, and he didn't. You know, just. Right. It was in his belly. Right? So doesn't that mean he ingested it? In food, like she tried to do the other times? Why should there be... oh, okay, I see what you're saying. If he took it. I see. I see what you're saying. Look it. Corey Richins did it. If she's found guilty, don't have an uneasy feeling because you don't believe that they proved something, okay? She absolutely killed him. It's so obvious. She had a boyfriend. She wanted to get rid of that life. She wanted to get all, you know. It's just, come on, you guys. You don't have to be a rocket scientist. I don't know, Gray. Did you watch it? No, I read The Probable Cause earlier, and at that point it was like, oh, Jesus. Whew. I'm sure it got even worse. No, they did prove it. They always prove it. Yeah. And you know how you'll know that they proved it? When she's found guilty. Whoa. What does whoa mean? Whoa. Yeah. Okay. We're just waiting for this to start here. You don't know what you're talking about, you bastard. You know what's weird is how many people want guilty people to get free just so they can be right in their assessment. Do you really want, like these idiots that want Koberger freed? I always say, okay, that's great. Can he stay at your house for the first month? And they always go, well, that's not the point. Well, no, just answer the question. If he's innocent, man, he is a great dude, man. Hotter than hell. He's got the curly hairs. He's... It's the same thing if you told, you know, these judges that let pedophiles out of prison, etc., or these killers out, you know, oh, they've been reformed. But I bet if you told the judge, hey, I'll tell you what, whenever you let these guys out, they stay at your house for a month first, then they get to go out into the public. They'd start going, I'm not watching you again. Yeah. I'm sure you're one of those types, Davey. Let's see. Yeah, no, it's weird. Like Tyler Robinson absolutely did this. All right, here we go. Here we go. I might have to boost it up, though.
Please be seated.
Don't forget to help support the channel, you guys.
Court is now in session. And
What do you mean?
video recording may begin.
Stalking my channel?
Calling case number
Weird.
251-501-576, State of Utah versus Tyler James Robinson.
Okay.
Counsel, please enter your
I'm going to
appearances.
boost it up.
Chad Brunander, Ryan McBride, Chris Ballard for the state.
Good morning to the prosecution.
Good morning, Your Honor. Richard Novak, Stacy Visser, Michael Bird present in court with Mr. Robinson, and Ms. Nestor is appearing by WebEx.
Good morning to defense. Good morning, Mr. Robinson. Do you have any other parties present?
Isn't that a song?
Good morning to you as well. All right. Before we begin, I want to address first issue, which is the issue of the December 11th transcripts. I'd appreciate an update as to the status of any proposed redactions. We've talked about this before, but I want to address it and see when I might expect those. Okay, so counsel, sorry, let me begin. In an abundance of caution,
God, why can't
we've
they get
turned
good
off the
audio? It's so
microphones
stupid.
at the desk, so nothing can be captured. You have to come to the lectrum.
He's a great judge,
What
this
you
guy.
have to say is important.
Yeah. He's really doesn't give a damn about,
Sure, to be cautious.
he's
Thanks.
very, wants
Your
it to be
Honor,
open.
I actually think the court reporter filed the transcript with the court last night, the redacted version, fully redacted, so I believe that's taken care of.
All right, well, that's good to know. Mr. Ballard? Yes. And you have to come forward, sorry. We're going to get our steps in today.
Just going to agree that that's, my understanding is that's been filed, we've agreed on the redactions, and so that should be taken care of.
Can you guys hear it okay?
Thank you, Mr. Ballard. All right, I wish to address media coverage and related considerations as it relates to this hearing. The court wishes to remind all parties that the February 25th, 2026 standing decorum order is in effect and will be enforced to protect the constitutional rights of all parties while preserving the integrity, fairness, and orderly conduct of these proceedings. I would also
Well, it
ask
comes out of
counsel to
one
be
side.
mindful
You gotta-
that the microphones, and we've turned off the microphones at your council.
It comes out of the left side.
But just to be mindful that microphones, even
So if you
through
don't have
the
stereo,
lectern,
you might be in
can
trouble.
pick up conversations. Council may wish to consider using screen protectors on laptops and taking reasonable steps, such as covering one's mouth when speaking.
Testing.
To avoid the inadvertent capture of private communications, whether by camera, microphone, or by those present
How
in
about
the
that?
courtroom. Third, the court wishes to address the camera operator.
Okay, Boo, go somewhere
and
else.
still
All right.
photographer. And so I respectfully ask Ms. Seitz and Mr. Dolan if you would step forward to the lectrum. Thank you. This is not intended to cause you any embarrassment or discomfort. I simply want to ensure that the expectations for today's proceedings are clear. So turning to Ms. Seitz first, during today's hearing, what is your primary role?
Still photography, pool photographer.
All right, Mr. Dolan.
Video and pool video.
Have you read the court's February 25th, 2026 standing decorum order, Ms. Seitz?
I have.
Mr. Dolan.
I have also.
Thank you. And so do you understand the guidelines as they relate to your responsibilities today, including the, as outlined in the decorum order?
I do.
Thank you.
I also do.
Thank you. Do you need any additional time to review the order or to reposition yourself or the camera to ensure full compliance?
I do not.
I do not.
Thank you. Do you anticipate any difficulty complying with the order?
I don't.
I do not either.
All right. Thank you to you both.
Thanks.
And I appreciate your cooperation today, and that we can make this proceeding move forward smoothly. Fourth, I want to turn to the state as it relates to discovery, and just want to see if we could have just a brief update. Mr. Grunander.
Thank you, Judge. Yes, For the record, we sent another batch of discovery to the defense as recently as last night. As far as the files that in our possession, we have provided 93.9% of those files to the defense at this point. We also, for the court's information, met with the defense yesterday, and part of the discussion centered on discovery, and we hand-delivered to them a hard drive containing information with respect to digital devices that had been seized as part of the investigation and analyses done by the RCFL, which is the Regional Computer Forensics Lab. That was a 24 terabyte hard drive. I don't imagine it was entirely full, but there was a large amount of information that was provided there. As I said, we met and talked about discovery. We talked about some of our expectations. We are candidly still waiting for some information. We had a meeting yesterday morning with some of our federal law enforcement partners, the FBI, the ATF, and talked about this issue of discovery and impressed upon them the need to have everything in their possession. We were assured that it's coming quickly. The ATF, for example, we expect to have their entire case file within the next week or so that we will disseminate to the defense. And we believe that that will have all of the underlying data in its original form that the defense could then use for their purposes with their experts. We are in the process also of reaching out to all of the local law enforcement agencies to ensure that we are in possession of all of the body camera footage from that day as well as other information. We continue to work on that. As part of our discussions yesterday as well,
Well, all I can tell you is there must be something wrong on your end.
what we anticipated presenting at the preliminary hearing.
This is really low here.
Scheduled for May. As
Hey,
far
thanks.
as,
K-me.
individuals that will testify as well as exhibits. We will be preparing, while it's not required under the rules, we are going to prepare a witness list and an exhibit list that we'll disseminate to the defense with Bates numbers so that it could be easily found in the case file. We are also helping the defense to facilitate a meeting for them to examine the physical evidence that's in the possession of SBI.
This part is
We
really
anticipate
low.
that
It's on the
probably
right-hand
happening
side. It's-
next month.
I don't know.
When
You can barely hear it.
We're back here, I think April 17th. And then lastly, we did also coordinate a meeting to meet with the defense today, this afternoon sometime, to walk the UVU campus so that they can take a look at the scene.
Okay. Thank you, Mr. Grunander. I appreciate the details. Does any party wish the benefit of the record as it relates to the discovery? Mr. Novak.
Richard Novak for Mr. Robinson.
Ooh, thanks. Bakalula.
We can either address this now or obviously.
Thank you for your
later
generosity,
This morning, as the court wishes. But there's a
And thank you, Tammy McDonald.
connection between the discovery that we have not yet received, that the Utah County Attorney's Office has not yet received, and going back one layer further, the State Bureau of Investigation has not received, which is directly related to our ability to meaningfully prepare for the preliminary hearing.
Okay.
And that is what I will generally describe as the federal forensic files. We're talking both about case files, as the ATF calls it, and data files from both agencies, which relate directly to forensic analyses, which led to forensic opinions, which it appears the state intends to move into evidence at the prelim through 1102. But we don't have much, I should say most of the underlying data. We don't have data that we've been able to give our experts on stuff that relates to those opinions. So we did meet and confer after yesterday's meeting about the fact that we need to ask this court to postpone the preliminary hearing for that reason. We can put it in writing if we need to do this by written motion. We can discuss it in more detail today.
Oh, they want to postpone the preliminary. Yeah, Jesus.
But it's not little tiny bits of witness statements here and there and reports and some photographs that we're missing. From our perspective, this is core fundamental data that underlies expert opinions that the state wants the court to consider. And we have no ability to either get our own expert opinions or meaningfully cross-examine the state's witnesses, or frankly, even call the forensic experts themselves, because we have a right to put on our own witnesses, because we don't have their data. And our experts can't advise us on the data if we don't have the data. So we can't meaningfully cross-examine, we can't meaningfully examine the state's forensic experts if the state decided to call them as live witnesses as opposed to through an 1102 process. And we can't be prepared to put on our own witnesses because they don't have the data. So I don't want to pre-argue it unless the court wants to get to the merits of that. I did go back and I looked at the court's comments back when the court set the May preliminary hearing date in December. And I don't think I need to read back to the court what the court said. But that's our concern. So we can either, from our perspective, discuss what is a realistic preliminary hearing date based on the representations that we will get certain data in the next couple weeks, which there's total good faith from the state council. When they said they met with the federal partners to impress upon them, I know what that means. That means they've done everything they can do, but there are federal agencies which haven't produced fundamental forensic data and files underlying very important expert reports. So we have the reports, but not the data.
Sure.
So we can either address that later today after the court hears the argument on the pending motions. We can move in writing, and the court could set a briefing schedule for that. We are cognizant of the fact that at the last hearing, the court said, if I may, we've got a really busy calendar. We don't have any openings. So we wanted to bring this to the court's attention today. Because if we just let this go and we file a motion, and then there's a response, and then there's a reply, and then I don't know when that hearing is going to be because of the court's calendar, that preliminary hearing date may be further out than these preparation issues require because of the court's calendar.
No, I appreciate that. I appreciate that heads up. And we'll revisit it at the end of this hearing. It's hope springs eternal in regards to discovery when it's passed over, and obviously the defense needs the necessary time to prepare as provided and the constitutional rights allow. And so I'm cognizant of that. So I appreciate the heads up, and I appreciate the work between the parties to move this forward. Let's revisit that at the end of today's hearing.
Absolutely.
Thank you,
Okay.
Mr.
Thank you, Your Honor.
Rivera. All right, well, let's turn to the matter that's before us. As this is the defense's motion, I will turn to you for your argument and your request. And just as a heads up, I'm battling a cold, so if I take a drink of my water, it's to spare you from coughing or an overly rough voice.
No problem.
Ms. Visser.
Yes, thank you. I will be addressing the motion to classify the January 9th motion, kind of taking these in chronological order here. I know this court is kind of drowning in First Amendment briefing, so I don't want to delve too much into that aspect. Certainly, I'm open to answering any questions the court has, but I kind of want to start with just the very base level. We are asking the court to classify this motion and the attachments as private under Rule of Judicial Administration 4-202.04. The reason that we are asking the court to do this fundamentally is because we believe that the release of this motion and the evidence has a reasonable probability of impacting our ability eventually to impanel an impartial jury and for our client to have a reliable penalty phase should that occur. I want to start kind of with a little bit of a procedural history here. Back in October, November, early in the case, the defense and the prosecution met and conferred about how the government would preserve evidence in this case. And when the government, the prosecution, and any law enforcement agencies sought to conduct testing that might impact the evidence in particular ways, they were to provide us notice. And if we could not come to an agreement about that, we are required to file something with the court to ensure that the testing doesn't move forward. That's what occurred here. In December, on December 22nd, we received notice from the state. They filed a certificate of service for that notice, and they also informed us in the correspondence, essentially, that they were not filing the notice because they were concerned about their ethical considerations under Utah Rule of Professional Conduct 3.6, which basically says we should avoid making public comments that influence a case, and the comments specifically talk about particular evidence that might impact a case, more likely to impact a case. We agreed with this. We did try to come to a resolution, but ultimately, at the end of the day, we needed to preserve the issue. So in order to preserve the issue, we had to file something with the court. And honestly, there was a lot of back and forth about whether or not we could file it publicly, how we wanted to do that, because we have the same concern that the state voiced in that initial email. Are we putting something into the public sphere that will inappropriately enter into the minds of potential jurors and impact the case? Ultimately, we decided that we have two obligations. One is to preserve the issue, to ensure our client's right to due process and his right to effective assistance of counsel needed to be preserved. We needed to file this and put the court on notice in a way that this court can make a ruling on it should that become necessary. And I will say, Your Honor, that we continue to work on this issue with the state. We're still negotiating it. We are not asking for a hearing on the underlying motion because we think we can likely resolve it. It was almost to the point where we contemplated potentially asking to withdraw the motion, but of course that doesn't really cure the record issue. So we are here. In addition to that, the other obligation, of course, is to ensure our client receives a fair trial. So we filed a motion to classify. When we filed the motion to classify, we did notify the state, and they took a slightly different position. They basically said, well, now that you filed it, we don't have the same concerns under Rule 3.6. I think those concerns remain. I don't want to talk about the evidence specifically in a public setting, so I'm going to choose my words carefully and maybe read a little bit more than I normally would.
Sure.
But the evidence is important enough. It is important. It is evidence that will be at issue in the case. But it is also in process, which is the whole point of the underlying motion, right? It's in process. There is more to be done. There is more the state wants to do with that evidence. So it is not in a place, in a position where we are going to be arguing about admissibility because it's not done, right? So what we're talking about is releasing preliminary evidence into the public sphere that has the potential to impact jurors. And it is important enough that we are concerned that it will sway people's opinions one way or the other. And I want to make clear that our concern here with selecting an impartial jury, really, it goes both ways. Whether the evidence is good for my client or bad for our client, whatever it is, it makes it harder to find impartial jurors if they are entrenched in an opinion about our client's guilt or innocence. Either way. So we don't want to be putting out evidence as the defense that will sway the public opinion. We've already told the court we're not fighting this case in the public. We're not trying to sway the public in favor of our client's innocence. That's not what we're doing. So, I also want to address one issue that I've seen generally arising in this case, and I think it deserves some comment. There seems to be an idea that flooding the public sphere with information or evidence from this courtroom will somehow dispel conspiracy theories or shift public narrative. That in and of itself is concerning to the defense. No one should be worried about that. All we should be worried about is protecting what happens in this courtroom. We believe that preemptively releasing evidence that we needed to provide to this court in order for this court to make an informed decision is just one of those actions, is one of those things that will negatively impact our ability to have a fair proceeding for our client. So we are asking that the motion and the evidence be classified as private, that this court consider our client's unqualified right to a fair trial and a reliable penalty phase should overcome the qualified right of access at this point. We understand things may change. This evidence may come in other ways at other points in the proceedings, like a preliminary hearing, or when we actually challenge the admissibility of evidence. But at this preliminary stage, we believe this is the appropriate course to take to protect the proceedings and our client's rights. Does the court have any questions for me?
Well, I do, but I'm going to wait till all of defense has presented. Is there another attorney that's going to be presenting?
Yes, Mr. Burt is going to present on the other motions to classify and the motion to close the hearing in part on April 17th, if the court is prepared to hear that.
All right. Yeah, I want to hear all of it, and then I'll have questions for you all. Thank you, Ms.
Sure.
Visser. Mr. Burt.
Morning, Your Honor.
Good morning.
Michael Burt for Mr. Robinson. I'm going to be addressing the motion to classify what I'll call the camera motion, the motion to restrict electronic media. So there's a motion to classify that motion as private. And then there's a motion that was recently filed to close the select portions of the hearing that is scheduled for April 17th.
And Mr. Burt, just for clarity, would you mind referencing the docket number of these motions?
Certainly.
And for Ms. Visser as well. I just want to make sure we're tying it well in the record. So,
Yes.
Because sometimes we use different terms about talking about the motions, and if we use the docket number in conjunction with that, it just clarifies it for everyone's benefit. And I didn't mean to catch you off guard or.
No, not at all, Your Honor. So let me take it chronologically. The motion to classify, motion to exclude still photographers, TV cameras, and microphones from the courtroom as private, that's docket number 310.
Thank you.
Then the motion to close portions of the April 7th hearing is document 425.
Thank you.
And there are,
That's
of
the April
course,
7th one.
oppositions to those motions. If the court would like, I can outline what those are.
No, I'll have the other side. I don't want to deprive them the opportunity of doing the same thing as you just did.
So in all, there's a lot of paperwork in front of the court, and obviously I'm not going to repeat everything in there, but one of the cases that's cited by all parties, I think, is the Utah Supreme Court opinion in Kearns Tribute Corporation, which is 685 Pacific 2nd, 515. And there are a number of key points in that opinion that I'd like to focus the court's attention on. And as the court may recall, the issue there was whether there was a public right of access to a preliminary hearing. And one principle the court sets forth in the opinion
My ads were on manual. I had
is
to
at
put them
page
in, but I didn't put
519,
any
where the
in.
court says,
I'm not sure if
we
you guys
believe
got
the
ads.
issue, quote, we believe the issue should turn on the precise nature of the proceedings in question. We limit our review to cases involving preliminary hearings. And then the court proceeds to explore the nature of a preliminary hearing and decides that because of the nature of that preliminary hearing, it, like the trial itself, should be classified as one that the press and the public have a right of access to. And the key portion of that discussion is at the following page, where the court says Utah's preliminary hearing is different from the preliminary hearing in some other jurisdiction in that it does not include hearings on motions to suppress evidence. Rule 7D1 provides, and then it quotes the rule, and the court goes on and says, as a result, the added risk of prejudice through pretrial disclosure of evidence targeted in a motion to suppress are not present in Utah's preliminary hearing. If the prosecution elected to try to use such evidence in the preliminary hearing in advance of a ruling on whether it should be suppressed, the defendant could seek special measures to avoid its public disclosure. So there I think the court is signaling that in a preliminary hearing context, if an issue of inadmissible evidence comes in, the appropriate procedure is for the defense to seek closure of at least that portion of the hearing where the evidence is going to be discussed. So the first point I wanted to make is court looking at the procedure we're asking to close a portion of, and that is the motion to preclude further electronic media coverage of the case. It is unlike a preliminary hearing in the sense that that hearing on the 17th is not going to include a motion to suppress evidence, obviously. It's going to include a discussion of the nature and extent of prejudicial pretrial publicity. And I emphasize prejudicial pretrial publicity because the cases define that term as a term of art. It does not include all pretrial publicity. We are not complaining about all pretrial publicity. We're complaining in that motion to close the hearing, which is the motion to prevent further electronic coverage. That's document 305. Our only focus there is on what the courts have characterized as prejudicial pretrial publicity. And that categorization includes the same type of information that Rule 3.6 prohibits lawyers from commenting upon. Things like confessions, things like evidence before it's been admitted, personal opinions as to guilt or personal opinions as to the appropriate penalty, evidence which is clearly inadmissible. Those are the categories of prejudicial pretrial information that the courts and the rule focuses on. So our motion to preclude further electronic coverage details, and what the media says in too much detail, the kinds of prejudicial pretrial publicity that have characterized this case so far. So the hearing and the standards that the court is governed by under the rulings that we cite, particularly the James case, the Utah Supreme Court case says, in deciding whether there's a reasonable likelihood of prejudicial pretrial publicity, the court has to consider a number of factors. And one of those factors, the size of the community, the nature and extent of the pretrial publicity. So as part of our burden, we have to show the court, through evidence, what is the nature and extent of the prejudicial pretrial publicity. And by definition, that prejudicial pretrial publicity is inadmissible at trial. So we're not dealing with a situation where the court has not yet ruled on a motion to suppress. That issue comes up in relation to the other motion that Ms. Visser just talked to you about. We're dealing with a motion that by definition is putting forth in front of the court evidence which is clearly inadmissible at the trial of this case. Confessions, alleged confessions, opinions and statements by Ms. Kirk, statements by the President of the United States, statements, opinions by the Vice President, by the Governor, by the prosecution, by law enforcement officials. All of that prejudicial pretrial publicity is by definition inadmissible evidence. So in that kind of a hearing, is that the type of hearing that we're going to hold on the 17th that should be subject to a right of access? The first issue which Kern says the court should consider. And my argument to the court is that it's not. It's not a traditional procedure such as a trial or a preliminary hearing where courts have recognized a right of access. But even if there is any sort of right of access to a hearing on whether the media, electronic media, should be excluded, the nature of that hearing has to be considered, and as Kern dictates. And I think the best description of the type of hearing we're talking about on the 17th is discussed by the U.S. Supreme Court in Estes versus State of Texas, which we cite in our 305 pleading. And in that case, like this one, there was extensive pretrial publicity, prejudicial pretrial publicity. And in that case, like this one, there was a motion to exclude further coverage by way of electronic media. And the court addressed the issue of whether that type of a hearing is something that in itself can give rise to prejudicial pretrial publicity because of the fact that the evidence that's being brought forth during that hearing is going to be by definition prejudicial. And the court in Estes, this is Judge Clark's opinion, says, this is at page 535 of the Estes opinion, it is contended that this 2-day pretrial hearing, that is the hearing to exclude the press, cannot be considered in determining the question before us. And the question before them is whether Mr. Estes was deprived of his right, federal constitutional right to a fair trial. And the court goes on, we cannot agree. Pretrial can create a major problem for the defendant in a criminal case. Indeed, it may be more harmful than publicity during the trial, for it may well set the community opinion as to guilt or innocence. Though the September hearing dealt with motions to prohibit television coverage and to postpone the trial, they are unquestionably relevant to the issue before us. All of this 2-day affair was highly publicized and could only have impressed those present and also the community at large with the notorious character of the petitioner as well as of the proceedings. The trial witnesses present at the hearing as well as the original jury panel were undoubtedly made aware of the peculiar public importance of this case by the press and television coverage being provided and by the fact that they themselves were televised live and their pictures rebroadcast on the evening show. So that kind of captures why we had to bring this motion, because we don't want to be in a position of inflicting another wound on Mr. Robinson's right to a fair and impartial jury by republicizing either right now in arguing this motion or on the 17th when the court hears from us what the nature and extent of that pretrial publicity is.
Well, let me stop you right there, Bert, and
Yes.
Mr. Burt. So you cite the Estes case, but Estes was overruled by Chandler v. Florida because in Estes there was an assumption of prejudice, but in Chandler it required the defense prove actual prejudice, and so it it changed a little bit. Can you talk a little bit about that?
Yeah, certainly. The Chandler Court, first of all, was asked to, but did not overrule Estes. But what it did clarify, as the court just indicated, is that if the defendant wants to prove up a federal fair trial violation, it's his burden to prove prejudice. And the Estes Court outlines that that can be done through an evidentiary hearing at which the defense would have the burden of showing, again, the factors under the James case, nature and extent of publicity, how it prejudiced the defense, whether there are reasonable alternatives. That's going to be the very purpose of the hearing, to comply with Chandler's mandate that we have the burden to prove that prejudice. And so we're going to be taking on that burden, and we think well establishing that we're entitled to the relief that we seek, which is some restriction on the type of prejudicial information that is flowing not only from the electronic media, but that electronic media being amplified by the widespread use of social media, which we discuss at length in the motion. I'm not going to get into the merits of the motion itself, but to address the concern the court had about, well, really Estes is no longer good law. Estes is cited favorably in Chandler. It's cited favorably in Hollingsworth versus Perry, which is the Supreme Court's most recent discussion of cameras in the courtroom. And the court is correct that Chandler put a gloss on it, that we have to show there is no presumption of prejudice, but there is a presumption of prejudice in regard to certain types of prejudicial pretrial publicity. And the clearest holding to that in that regard is the Schilling case. Schilling says there is no presumption of prejudice unless certain categories that the courts have recognized as prejudicial are proven, and then it's inherently prejudicial. And the example that Schilling cites is publicity about a confession. And it cites back to the Wilbert Rideau case, Rideau versus Louisiana, where the court reversed the conviction because the defendant's confession was broadcast prior to the trial. So we have that type of prejudicial pretrial publicity in this case, and it's outlined in the motion. And so, yes, if you don't have those categories of prejudicial pretrial publicity, you have to prove prejudice. But there are certain well-known categories that do give rise to a presumption of prejudice. And that's reflected also in Rule 3.6, which says there are certain things lawyers should not be commenting about. And so we'll show both that we have categories of prejudice that are recognized as presumptively prejudicial, and we'll show that beyond that, the overall picture of this case is one of extreme prejudicial pretrial publicity that justifies the kind of relief we're asking for. But how do we show that without re-inflicting the very harm that we're seeking to avoid here? And that's the purpose of our motion. And the main concern is the tendency in this case for the press to, first of all, highlight all of the prejudicial information in virtually every story they feature on the case, which has its genesis in the prosecution's initial press conference before the court imposed its publicity order. There was an extensive press conference which got before the public a great deal of the kinds of evidence which Rule 3.6 says should not be disclosed before the court had the occasion to enter that order. And then that evidence has been re-amplified, commented upon, so-called experts have been brought in, lip readers, body language experts, all of that is outlined in the motion. The kinds of reiteration of this prejudice that we're most concerned about, the best example of that in document 344, which is the reply brief on this closure issue. At page 6, there is a link to an article. And that article concerns a story by one of the media's clients in which they were supposedly reporting on a defense anticipated motion to modify the court's publicity order. And the story does not concern, it's a television story, and the court has to see it to understand what the issue is, but the story does not concern what the merits of the motion is. The story focuses on, let's repeat for our audience in a very dramatic fashion all of the prejudicial statements made by politicians from the president on down, characterizing Mr. Robinson as an animal, characterizing him as evil, characterizing him as deserving of the death penalty. And they string together all these quotes and rebroadcast them. And that's the kind of coverage that's, I cite that as one example. But if the court sat down and touched on all the links we have in the 305 motion, the court will see it's repeated over and over again. So we don't want to be in that position of putting in front of the court all of this prejudicial information, then having the press regurgitate it yet one more time and re-inflicting the wound that we're seeking to avoid. That same link to that same article is in document 305 at page 175. It's interesting that the media's answer to this which I'll discuss, but I think I first need to return for a minute to the Kearns case. To continue with the other points that I wish to emphasize from that case, the third point from that case is the standard that governs what we have to show. And the court, in the opinion, says we don't have to show a clear and present danger to Mr. Robinson's right to a fair trial, but a realistic likelihood of prejudice. That's the standard the court will apply. And if the court looks at the standard for excluding electronic media, it's similar: reasonable probability, reasonable likelihood of prejudice. That's the applicable standard the court will apply. And the court also outlines the procedure to be followed on the motion that we're conducting right now. That is the motion on the hearing of whether the proceeding should be closed. And the court says, first, the hearing on the motion for closure should be open to the greatest extent possible, referring to this hearing that we're conducting right now. And then the court says, second, if disclosure of the alleged prejudicial material is essential to the conduct of the hearing on the motion for closure, the court should first seek a voluntary agreement from the parties who wish to be present that they will not disclose the alleged prejudicial information until it is disclosed at the trial or the trial has concluded. Absent such an agreement, the court may close the courtroom in order to conduct in camera whatever proceedings cannot be conducted without disclosure of the allegedly prejudicial information. So as I read that, the court's referring to the people presently in the audience who wish to be present during this hearing today, and that if they can't promise that they will not use information that I want to disclose in support of the motion today, then the court should conduct procedures in camera. Now, is it necessary for me to disclose to the court what my prejudicial information is? The media says in their motion that they filed yesterday, which is, I don't think I have a docket number for this, but it's entitled News Media's Memorandum in Opposing Motion to Close Portions of the Hearing, which is filed on the 12th yesterday. I don't have the docket number. I'm sure the media does, if there is one. But what they say is it's really not necessary for me to disclose to the court all the prejudicial information that we're relying on to justify moving to close, because at page 2, they say, if the defense does not want to highlight certain information at the evidentiary hearing, it can choose not to. The information is already cited in the motion to exclude, so the court can find it there. That would be a good solution, except for the fact that the media is also opposing our request to keep the motion private. So it doesn't do us any good to refer the court to all the prejudicial information in the motion if the court accepts the media's position that that motion in itself has to be disclosed to the press. Because if it is disclosed, they're going to take that motion and they're going to reiterate all the highlighted prejudicial information in that motion, and again, defeat the very purpose of filing the motion. A couple of other points that I wish to emphasize to the court. One is, in both the present motions that I'm talking about and the motions that Ms. Visser just responded to, the media and the state, and the state are in, and the media are mini-me's of each other on this issue. Their pleadings are virtually identical, which calls into question why the media is even a part of this hearing. The court has not yet decided whether they have standing on this particular issue. And in your December ruling, you said that we were not obligated to file with the media the motions concerning restricting electronic media. In their latest opposition to the closure motion, they discussed their standing. But one of the issues in standing is whether we need the voice not only of one media lawyer, but of two media lawyers, asserting the same position that the state, one of the parties in this case, is asserting. So you're being presented with three different lawyers arguing essentially the same position. And when the court denied intervention to the media in this case, it cited the Utah Supreme Court decision in Society of Professional Journalists of Utah versus Bullock. And there the court, Utah Supreme Court, addresses the issue of standing in detail. And and there were multiple media agencies in that case. And one of the points the court makes is that although there are multiple media agencies, they're all representing the exact same interest. That is the interest of the public in open access to the proceedings, which is coincidentally the same interest the state is asserting in reference to this motion. So we do question whether the state even has standing, but
You mean the press?
I mean the press.
right.
I'm sorry,
Okay.
I misspoke. But putting that aside, both the state and the media stress to the court that the court should deny the motion to close, should deny, obviously, the motion to restrict media access, and allow the kind of prejudicial publicity that has characterized the case to continue, because we can all sort it out at trial through venue, motions for change of venue, through voir dire, or motions to expand the jury pool. And I wanted, that issue is addressed in detail in our underlying motion, the lengthy motion. But just to highlight a couple of the points that we raised there, one of them is the Utah Supreme Court, in a case that Ms. Nestor is currently involved in, the Richens case, and this is cited in our motion, said that the court does not have the authority to expand the jury pool. So that remedy is not one the court can adopt. And in terms of the other remedies that are being suggested, neither the state nor the media cites what I think is a controlling case on this issue, which is Gentile versus State Bar of Nevada, which is 501 U.S. 1030, discussed in our motion. But there, Chief Justice Rehnquist, writing for the court, who is no fan of the criminal defendants, said, quote, even if a fair trial can ultimately be ensured through voir dire, change of venue, or some other device, these measures entail serious cost to the system. Extensive voir dire may not be able to filter out all of the effects of pretrial publicity. And with increasingly widespread media coverage of criminal trials, a change of venue may not suffice to undo the effects of statements such as those made by petitioner. So I don't know how many capital cases that media lawyers have been involved in, but for the last 40 plus years, I've done nothing but those trials. And I've been involved with using jury questionnaires, extensive individual sequestered voir dire. And the fact of the matter is that voir dire is not an effective means in these cases. And to the extent it is effective in excluding people who hold prejudicial opinions, it calls into question other rights that are implicated. For instance, in a death penalty case, the jury has to be death qualified, both those who would automatically impose death and those who would automatically impose life. And there's a lot of research, this is an issue which will be explored down the line, but there's a lot of research which shows that that process skews the panel as unrepresentative. It excludes people who are knowledgeable because they read this media coverage. It excludes, the evidence shows, minority groups, women, and people that normally would be included in a representative jury. So yeah, you can voir dire a jury on whether they've heard the President of the United States say that Mr. Robinson should be executed, and you can exclude that juror from serving on this case, but given the demographics of this county, you're going to be excluding a large portion of the population. And then when you add to that the death qualification process, you no longer end up with a representative jury. You end up with what the U.S. Supreme Court in Witherspoon versus Illinois called a group organized to return a death verdict. But it's not a representative jury. So as Chief Justice Rehnquist said in his opinion, even if you employ these other means, they come with a great cost, and in this case, a great constitutional cost. So those are the main points I wanted to make to the court, and I hope I haven't repeated things that the court is already familiar with, but I'm certainly happy to answer any questions the court may have.
Well, what I think I'm going to do is wait till the state makes their argument, and then I'll have questions. That's going to put the picture together for me.
Great.
And then have questions for all parties. I just want to make sure I hear it all, and I appreciate your arguments, Mr.
Makes
Burton.
sense. Thank you, Your Honor.
All right. Turning to the state.
Your Honor, Christopher Ballard on behalf of the state. First of all, let me just set the table for the court because I think there's a motion pending that defendant didn't mention, and that's the motion to classify the reply brief in support of their motion to exclude cameras. Would Your Honor like that docket number?
Yes.
That motion is docket number 400. So as I understand it today, we've got 4 motions in front of the court, 3 of them dealing with classifying documents that have been filed. First is the January 9th motion. Then we've got a motion to classify the motion to exclude cameras, which Mr. Burt has just addressed, a motion to classify the reply in support of that motion to exclude cameras, which I just mentioned is docket number 400, and then also a motion to close portions of the hearing in April that Mr. Burt has also addressed. So it's my understanding that we're here on those four motions. Would it be helpful for the court for me to give you the state's oppositions to those motions, the docket numbers for those?
That would be helpful, Mr.
Okay.
Ballard. Thank you.
Sure. So on the January 9th motion, state's opposition is docket 340. On defendant's motion to classify the motion to exclude cameras, the state's opposition is docket number 346. On the defendant's motion to classify the reply supporting its motion to exclude cameras, the state's opposition is docket number 431. And then on the motion to close portions of the April hearing, the state's opposition is docket number 448.
Thank you.
I think part of the problem with this is on three of these motions, we don't have any requests to submit. There is a request to submit that the media helpfully filed on the January 9th motion, and that lists all of the docket numbers of the relevant documents. There's been quite a few on that one. So hopefully that's helpful for the court.
Yes.
Okay, the next thing I want to clarify is the standards that apply to these two different categories of motions. The defense here has not been very careful about articulating and applying the correct legal standards that govern these motions, because there are different standards that apply to classifying documents as opposed to closing a hearing. The standard that applies to classifying documents is found in the Utah Rules of Judicial Administration. That's Rule 4-202, 0.04. But the standard that applies to closing a hearing, as the state explained in its opposition, is governed by case law, and that's the Kearns Tribune case and subsequent cases following that case. And then I also want to just clarify that Rule 3.6 of the Rules of Professional Conduct that's also been mentioned, that rule, while it might be relevant because it talks about pretrial publicity, it does not govern any of these motions. Because Rule 3.6 talks about lawyers making extrajudicial statements. We're not concerned about any extrajudicial statements in any of these motions or in closing the hearing. Obviously, everything that's going to occur in the hearing is going to occur in court. And I also just want to emphasize that Rule 3.6 makes it clear that there's nothing improper about a lawyer commenting on information that's contained in a public record like the information that's filed in a criminal case. Now, with respect to the first motion to classify defendant's January 9th motion that has to do with the evidence, the state did mention Rule 3.6 when it submitted its notice of intent to test evidence. The state did that because the state recognizes that under Rule 3.6 there can be concerns about statements that deal with evidence and testing and results of tests. Our hope, and I guess it's proved to be overly optimistic, was that if we could do this without having to file something in court, we could get this issue resolved of whether we could go forward with the testing. We'd get that resolved. We wouldn't need to be here in a hearing like this today arguing about whether something needs to be public or private. We could hopefully move forward, get the testing done, and get us that much closer to trial. The state was not suggesting that there would be anything improper about filing a motion and having this type of evidence listed in a public document. So that was not the state's intent in originally mentioning Rule 3.6. We were just recognizing that there could be concerns, and hopefully, in hopes of avoiding any kind of hearing like this and getting this issue resolved as far as the testing goes, that we could move forward. But we find ourselves here. Now, another thing I want to clarify is we are not media lawyers. We are not representing the interests of the media. Our client is the people of the state of Utah, who do have an interest in the public nature of these proceedings. But whether any particular document in this case is public or private is really of secondary concern to the state here. We're not trying to represent any kind of media interest, and I think it's improper for the defense to suggest that. Although maybe the media might want to hire us because we probably charge much lower rates than the media's lawyers. But we're not representing the media's interests. We are just, our primary concern is moving this case forward and applying the correct standards in the law. So with that, let me turn to the substance of our response to the motion to classify the January 9th motion. It's clear from the rules of judicial administration that that document, having been filed with the court, is a presumptively public document. And a general allegation that it discusses evidence that might be inadmissible is not enough to deny public access. If that were enough, then any motion that discussed evidence before there was a ruling on the admissibility of that evidence would have to be private. And even if there were some basis for ultimately finding that the evidence discussed in the motion was inadmissible, public exposure to that kind of evidence does not necessarily justify or it does not necessarily prejudice defendant's right to a fair trial and justify sealing that document. And the controlling case of State versus Allgaier here from the Utah Supreme Court in 2011 is very instructive on this point. It's instructive to all of these motions. Allgaier was a capital case. And the issue in Allgaier concerned a letter that was sent to the court from a fellow inmate of Curtis Allgaier, the defendant in that case, who'd been charged with capital murder. And the letter stated that the defendant had confessed to aggravated murder and also threatened the inmate and the inmate's mother if the inmate revealed that confession. I can't imagine any more potentially prejudicial information in a capital case. It's a clear admission of guilt. It's a clear admission of future dangerousness. So the defendant in that case obviously wanted to keep that letter private. But the court denied that request because that information that was in the letter was already contained in the public record. Now that fact is not necessarily relevant to this motion to classify the January 9th filing, but it is relevant to the rest of the motions here. But what the court said next in affirming the trial court's decision in Allgaier to release that letter is really instructive, because the court recognized that despite already circulating reports of highly prejudicial information, there were alternatives to restricting public access to the document. And those reasonable alternatives are the time-honored tools of jury selection. That's how we screen out jurors whose prior knowledge renders them unable to objectively view the evidence. And I think it's interesting in Allgaier that the court said those tools would be effective to protect the defendant's right to a fair trial, regardless of how that balancing came out, whether the court said, yes, this is so prejudicial, it shouldn't be released, or the prejudice is, the risk of prejudice is not high enough to justify restricting access. That ruling, that holding in Allgaier coincides perfectly with the United States Supreme Court's analysis in the case of Press Enterprise 2, where they mentioned as well that through voir dire, a court can identify those jurors whose prior knowledge of the case would disable them from rendering an impartial verdict. And as far as this notion of the court can't expand the jury pool, that's certainly not the case. The court can summon as many Utah County jurors as it deems necessary to be able to seat a fair and impartial jury. What happened in the Richens case is that given that Summit County is a smaller population county, they tried to expand the Summit County jury pool with jurors from Salt Lake County. And there's nothing that allows you to take jurors from a different jurisdiction and add them to the jury pool. But we're here in the second largest county in the state. There's not going to be any problem with expanding the jury pool here. I'll just briefly touch on, as far as the other two motions, to classify the motion to exclude cameras and the reply in support of that motion. I think basically the same arguments apply. The only thing I would add there too is that this idea of where there's so much media coverage that you've got to necessarily find that there's some prejudice. I don't know that it necessarily works that way. I think that the fact that media coverage becomes so pervasive can also tend to dilute the effects of that media coverage, because when something becomes a constant drone, a lot of people tend to tune it out. Now, for sure, there'll be people that are fixated on this case, but we weed those out through careful questioning during voir dire. And I also point out that not all media reports in this case have been unfavorable to the defendant and favorable to the state. It's gone both ways here. There's media that the state's concerned about as well. So just saying that this is a content tornado or there's been a barrage of media coverage doesn't necessarily mean that there is going to be prejudice to the defendant. I'll turn then finally to the motion to close portions of the hearing. And again, there's a different standard that governs that motion. It's not governed by the rules of judicial administration. To close a court hearing, a court has to look at the specific nature of the proceeding at issue and determine, first of all, whether there's a presumptive right to public access to that type of proceeding. Now, defendants waived any argument that there's no presumptive right of public access because he hasn't argued otherwise. Instead, he's assumed that there is a right to public access and has argued for the court to close that hearing. But again, defendant has incorrectly relied on the standards that govern classifying documents rather than the standards that govern closing a court proceeding. But the same arguments still basically apply, that the defendant would have to show that the closure is necessary to protect his right to a fair trial, and we don't believe that he could make that showing where most of the documents, or most of the evidence that's going to be discussed at that hearing is already public, and that's where that other portion of the Allgaier case comes in. If you're going to be discussing things that are already public, that tends to favor keeping the proceeding public rather than closing it. Now, the state does agree with the defendant on 2 points in that motion. To the extent that the hearing is going to discuss media coverage that has violated the court's decorum orders, we would agree that those portions of that hearing should be closed, because that would be just committing further violations of the court's decorum orders by repeating that evidence. And then defendant has also mentioned that there are personal privacy concerns to some people, and that they want to discuss media reports that have created concerns about personal privacy and safety, and the state would agree that those concerns are sufficient to justify closing the hearing. So we would agree with the defendant that portions of the hearing that discuss decorum order violations and that implicate personal privacy and safety, those should be closed, but otherwise, that April 17th hearing should be open, especially where it's just going to be talking about things that are already public. Does Your Honor have any other questions?
Not just yet. Thank you, Mr. Ballard.
Thank you.
Any other arguments?
Yes, Your Honor.
Thank you. And counsel, remind me your name.
And for Your Honor's benefit, I intend to handle the argument on the motions to classify, and Mr. Jed intends to handle the argument on the motion to close the April 17th hearing.
Thank you.
So I'll start with the motion to classify the January 9th, 2026 motion. That's docket 285. And for the court's benefit, the news media oppositions are at docket 302, docket 337. And then we also filed a supplemental opposition on March 10th. I don't believe that has been filed on the docket yet because we filed it under seal and there wasn't a way for us as non-parties to file it on the docket. I will note that I do think the court granted our motion to file under seal, but it looks like the motion that was sealed, the opposition that was sealed was, I think, the incorrect opposition. I think the sealed one was docket 451, and that should have been kept public, whereas the one we sent to the court via email is the one that should be sealed privately.
Thank you for that clarification.
Yes, and we can clarify it again later if that's helpful. So starting with the motion to classify the January 9th, 2026 motion, and before I get into our arguments, I'll just clarify that I don't intend to comment on sort of the substantive arguments in the motion or the underlying evidence referred to. So as the state argued, filings are presumptively public. That's in the rule, it's clear as day. I do want to differ from the state a little bit though. So Rule 4-20202 sort of explains what the court needs to do when it's deciding whether or not to keep a filing public or to allow it to be sealed. What that rule doesn't exactly do is tell the court what sort of is the standard that it's applying when it's weighing the interests. And for that standard, I would refer the court to Press Enterprise 2. That's 478 US 1. And I know Mr. Judd intends to talk about this a little as well, so I won't go into too much detail. But that's the case from the U.S. Supreme Court that was decided after Kearns Tribune, which the parties already referred to. And in that case, the court said that when a court is deciding to close a proceeding, so it wasn't referring to filings or documents specifically, but it was talking about a proceeding like a preliminary hearing. It said the court has to make specific findings, and there has to be a substantial probability that fair trial rights will be prejudiced. And the court was very clear that the standard is substantial probability. And then the court also said there has to be no less restrictive alternatives. So that really maps nicely onto Rule 4-20202. The only difference being that in Press Enterprise, the court clarified the standard is substantial probability of prejudice. And although that case was referring to hearings, open hearings and open court filings are just two sides of the same coin. They're stemming from the First Amendment, they protect the same interests. So there really is no need for the court to consider or apply a different standard for open filings or open proceedings. It can really be that Press Enterprise 2 test. But really, whether you're looking only at Rule 4-20202 or whether you're looking at Press Enterprise 2, the outcome for this motion in particular is the same. And that's because, as Mr. Ballard referenced, filings are presumptively public, and that doesn't change just because the court hasn't ruled on the admissibility of the evidence. You can look at, for that standard, you can look for cases like State v. Archuleta, that's 857 P. 2nd 234, that's the Utah Supreme Court. Also the Algier case, 2011, UT 47. There, the defendant made the argument the letter would have been inadmissible, and the court still said it should have been made public. And then also even United States versus McVeigh, which is a case cited by the defense, and that's 119 F. 3rd 806, and that's a 10th Circuit case. And then I finally, just the final point I want to make on this motion is the arguments from the defense about why this motion needs to be kept sealed are really quite generic arguments about pre-trial evidence. They could have been applied in any type of case to any type of evidence. And I understand that the defense is being careful because we're in a public setting. I understand and appreciate that. But the arguments in their sealed filings were just as generic and just as applicable to any type of pretrial evidence. And as we argue in our supplemental opposition, we don't think the actual arguments made in the motion justify that this type of evidence needs to be kept private. So unless Your Honor has any questions about that motion to classify, I'll move on to the next two.
Yes, go ahead.
So the next two motions to classify are relating to the motion to exclude cameras, and that is dockets 310, that's the motion to classify the primary motion, and then docket 400, which is the motion to classify the reply in support of the motion to exclude. And the news media oppositions can be found at docket 323 and docket 429. So for these motions in particular and the reply, I just want to make very clear that you cannot make public information private by putting it in a court filing. That's because filings are presumptively public, but also because, again, the information is public. You can't take a public thing, put it in a public forum, and it suddenly ends up being private. That just is not how the rule works. There has to be some sort of showing as to why this information can't be made public, but again, it already is public, including, in fact, information that was created by the public. So if the motion to exclude is kept private, what that's saying to the public is you can't have access to information that you, in fact, created. Similarly, the court cannot prohibit the public from discussing information that is already public. That is a prior restraint on speech. If there is news articles, if there are comments from public officials, the news has a right to report on that. The court cannot control that. So making this motion and this reply private or sealed, that's just not something that can actually control the speech. So this attempt to sort of control the public discourse, it's just ineffective, and it's also unconstitutional because it is a prior restraint on what can be reported on. The defense's argument there is that they shouldn't have to republish the information, but nobody is asking them to republish the information. They have decided to assert these arguments in the motion. They have decided to include all of this evidence. That was their decision, and they put it on the court docket. So the presumption is that it is public. And the news media, in our opposition to that motion, not the motion to classify, but the motion to exclude cameras, one of the points we made is that a lot of this stuff doesn't even deal with electronic media coverage. It's referring to statements made by public officials before the proceedings even began. So the defense's position that they had to include these things, we would push back against, because we don't think a lot of the things cited are even relevant to the actually narrow question that is before the court about whether electronic media coverage should continue. Because some of those statements aren't even really connected to electronic media coverage. They're connected to things that public officials said or did before the proceedings began. And we don't have a dog in that fight. We're not trying to litigate whether or not that was lawful or not. We're just trying to litigate, should electronic media coverage continue? And so the defense really didn't need to include, we argue, a lot of the things they did include, that again are public statements that the public has a right to see and have access to, and in fact already has access to. So there is no reason to exclude the public from seeing those things. And for that argument in particular, I would again refer the court to Algier, where the court talked about that very specific point, saying if the information is already in the public, then there's not anything the court can do by trying to restrict that information. Again, the best tools available to the court are the time-honored things that the court can control. The court cannot control public discourse, but it can control the jury that is actually seated and ensure that that is a fair and impartial jury. And so that is the best method. Are there any questions Your Honor had on that motion?
No, thank you.
Yep, and before I sit down, I also wanted to add, I am prepared to address standing. I didn't know if that was something you wanted to hear from the news media today, but I am prepared to address that if you would like.
Right now, no, thank you. Mr. Judd.
Thank you, thank you, Your Honor. As Ms. Uresk suggested, I'm going to address briefly the motion to close the April 17th hearing in part. The docket numbers for the briefing on that are docket number 425, that's the defense's opening motion. Docket 448, that's the state's response. And docket 451, that's the media's opposition. Ms. Visser at the outset said something that I'm sympathetic with. I know the court has a lot of briefing before it on these motions. And she mentioned that it felt like we were drowning in a First Amendment briefing. I don't think anyone wants to drown, but if I had to drown in something, I think I would drown in First Amendment briefing. Sounds delightful. The court ultimately needs to make a practical decision about each of these motions in front of it, and that's a tough task. And I want to help the court with that the best that I can. If the court is going to close or seal anything, the court has to make findings, and the court has to explain which interests it's weighing. It also has to do an important thing in determining that the restriction it's imposing on public access is the narrowest possible way of protecting the countervailing interests in favor of secrecy. So that's tough. The court's been through that several times already, including with the motion to disqualify and the hearing there. How do we identify an interest that we may believe justifies an exception from this rule that the public gets access to these proceedings? And then how do I make that as narrow as possible to ensure that if that interest needs to be protected, I am, but it's narrow. I'm grateful, therefore, that the defense, got this motion on file in time for us to discuss it today, so we can talk about that April 17th hearing today in advance. And I'm also grateful that that motion and both oppositions recognize what I think has to be the case, which is most of that hearing, if not all of it, needs to be open. The two sides have talked about the kinds of hearings that are presumptively open. This is one of those. There's no reason that it shouldn't be. It's not a juvenile matter. It's not another type of sensitive matter that would qualify, and any argument to the contrary has been waived. So we start with the presumption that this is open. The defense also recognizes, I think, that most of it should be anyway, that the things that they seek to protect are some narrow categories of information. I think where we run into challenges is a lack of specificity. And if we can't get to the specifics, justifying what exactly would need to be closed and why, then the presumption wins and it stays open. I see in the motion an argument that something about what they call a litany of potentially prejudicial statements may not want to be introduced. But of course, for the court to enter a ruling saying, okay, that part of the hearing will be closed, we have nowhere near the kind of specificity we would need to say what that would even look like. Would there be some sort of short colloquy where certain pieces of evidence would be introduced? If so, what? A certain statement by a public official? A certain news clip? A certain statement? We don't know. Because the motion that will be discussed at the April 17th hearing is 185 pages long, and it has, again, a litany of information. It's possible that there may be some part of some piece of evidence in that weighty motion that the court may be better to review in camera, right? So as to not publicize it again and risk this republication problem. But we don't know what that is at this point. Another suggestion is that the December 11th closed portion may be discussed there. I think that's gone. I think we now have a transcript that has almost all of that hearing open. The last piece is that there may be some kind of private and personal information. Sorry, there's two more. There may be some sort of private personal information, potentially for a witness. The court has, very narrowly in the past, in this case, identified one instance where keeping at least one bit of identifying information off camera may be appropriate. Maybe the court would see fit to do so again here, but we don't know what the ask is. And at this point saying, okay, I will grant the motion to close a portion of that hearing to the extent that it implicates some kind of private information would be impossible for the court to do, because the court can't do that balancing test that the rule requires without that type of clarity. The last piece is alleged violations of the decorum order. Again, I struggle a little bit to understand exactly what would be presented that would justify closure. I think discussing, hey, we believe in these cases and these types of media coverage, there was something that was a violation. Something was shown that shouldn't have been, and here's the problem that it creates. Again, if we want to show the media clip in which that decorum order violation was broadcast, I think that wouldn't justify or necessitate closing the hearing. The court could look at it on its screen. The defense could refer to what we're going to show you right now is the following kind of violation. In short, I think the task that's been put in front of the court to attempt to close part of that hearing right now is impossible. What would the court say, I am going to close at this point, when everybody decides that the vast majority of that hearing needs to be open? It may be possible when we get to that April 17th hearing that the court may be faced with a request to say, here's what we're going to present. We're going to put this witness up, and this witness is going to talk about this thing. And it may have a more complete ability to rule on that specific issue then. But as of right now, I think not only should most of that hearing stay open, which everyone has agreed to here, but in the media's view, everything should. The last thing that I want to mention is the unique feature, the unique nature of this hearing. There's all kinds of different hearings, and they may, preliminary hearings, evidentiary hearings, the trial itself, those all may have different standards. What's unique about this hearing, of course, is that this motion asks the court to turn off cameras, to mute the microphones, and to no longer let the public be the kind of participant in this hearing that it has, in this proceeding that it has been to date. Saying, not only should the cameras be turned off, not only should the microphones be turned off, but the argument as to why that should happen should be sealed from the public, and the public kept out of that hearing. Strikes me as the exact opposite of what the presumption of public access is meant to do. Of all the types of things that the public should be able to see argued, a question as to whether or not the public will be able to continue to observe the proceedings in the case seems like close to the highest potential instance in which public access should be granted in that case. We think this hearing should be open. The parties are taking all the measures that they can, and I know we have hard work from our people here representing the media and the public to try to abide by the court's decorum order. The court has done heavy lifting so far to initiate and refine that decorum order to balance the interests. We believe that that is the approach the court should continue to take, to continue to allow access, but to have appropriate restrictions to balance the interests. And we ask the court to do that with respect to the April 17th hearing as well.
Thank you, Mr. Judd. Defense, do you want to have a response?
Responding first to Mr. Ballard's arguments, Your Honor. Quote, we are not concerned with extrajudicial statements. That is not correct. The motion, and also responding to Mr. Judd's argument that we're not specific as to what it is we don't want publicized, that the motion sets forth 305 in great detail, the specific prejudicial pretrial publicity that we think prejudices Mr. Robinson's right to a fair trial. So it's hard to understand in light of the length of that motion and the detail at which the prejudicial publicity is set forth, how a media lawyer can stand before you and make a statement that we have no idea what they're asking to be excluded. What we're concerned about, as I indicated in the argument, is the specific categories of prejudicial information outlined in 305 that state opinions, extrajudicial opinions of public officials, extrajudicial opinions of the prosecutors, of law enforcement authorities. So when Mr. Ballard said we aren't concerned with extrajudicial statements, we are concerned with that. And those extrajudicial statements are outlined in the motion itself very specifically, so the court has in front of it. And if it would assist the court, we could proffer to the court a proposed redacted motion, which would take out everything identified in that motion as prejudicial pretrial publicity. I think it's obvious from the face of the motion what that information is, but if it would assist the media in understanding exactly what we're talking about, we're more than happy to do that, and if that would assist the court. The idea that one of the media lawyers said, oh, the statements of public officials are not connected with the media. I can't understand, for the life of me, understand what that means. The media publicizes those statements, and if the court looks at all of the electronic media coverage that we've got outlined in the motion, the court will see it's a very slanted, biased rendition of the prosecution's version that Mr. Robinson is guilty and should be sentenced to death. There's no impartial reporting in any of the electronic media. So when the media lawyer says, this coverage is, they're just public officials, we have no control over them, we're not in any way responsible for what they say or what they don't say, that is false. They are responsible in the sense that they are putting in front of the public a distorted view of an incriminating portrayal of Mr. Robinson. And that theme of incrimination is repeated over and over in virtually every one of the clips that we provided to the court. And we've emphasized that those clips are merely the tip of the iceberg. And we will present during the hearing much more than what's presented in the motion to prove that very point. And so there is a connection. And it's not only the electronic media, but the social media who is taking this information and spinning these theories of incrimination. Mr. Ballard says, oh, well, it's not, we haven't told the whole picture because some of that is pro-defense, and he indicates in his pleading that they're going to put in at the hearing publicity concerning conspiracy theories that are out there. And the implication is that those conspiracy theories somehow help Mr. Robinson. But we're on the side here of using this trial as a method to find truth. We have no interest in advocating conspiracy theories, whether they help Mr. Robinson or not. So I think it'd be helpful for the court to see some of these conspiracy theories. But the main point is the public is not being educated by electronic media. They're being biased by it, and they're being slanted to extreme views on both ends of the spectrum. And that's where the court, under the Maxwell case, says the trial court has a primary responsibility to step in and take measures that could lessen the impact of that publicity. The idea that it's already out there, and the Algier case.
The judge just needs to stop all this shit. But listen,
because I think if anything, it's
we're not going to argue anymore about pretrial publicity.
The court in that case was concerned.
We can
with
find
an
an impartial jury.
Jailhouse informant.
We're going forward.
Who claimed
next
that
hearing
Mr.
is the
Algier,
probable cause. See you there.
His
Bye.
Name, had confessed to him in a jailhouse conversation, and the trial court refused to seal the letter because there was already other publicity. We don't know what that other publicity is. It's not detailed in the Utah
Also, if you
Supreme
guys could please help
Court's
support
opinion.
the channel
When
out
the
there.
case
My channel
reached the
relies on you
Utah
guys.
Supreme Court,
So if you can
critical
buy
fact
some
for
channel
the court,
memberships for
the
people
Supreme
or
Court was that in the
whatever,
briefing
thank you.
in front of the Supreme Court, Mr. Algier had included the letter that had been sealed by the trial court pending the appeal. He himself disclosed the content of that letter. And the Utah Supreme Court said, in affirming the decision of the district court that the interest favoring unsealing the letter outweigh the interest that favor keeping it sealed, we note that since the time of the district court's decision, most of the significant information contained in the letter had been introduced into the public arena. Specifically, in his brief in this court, which is a public document, Mr. Algier included the third district court's decision to unseal the letter. That decision, which was filed under seal, quoted the letter. because these portions of the letter have been placed by Mr. Algier into the public arena and are therefore accessible to the media, any significant interests that would be protected by requiring the letter to remain sealed are now greatly diminished. So how does that case compare to this one? Well, first of all, we're not dealing with information that the defense has voluntarily put into the public domain. In Algier, there was no motion to file the letter under seal by Mr. Algier. In this case, we filed all the relevant pleadings here with a request that they be classified as private. So counsel for the media misspeaks when they say, oh, well, once it's filed, it's
He's
in the public
already
domain.
heard
The
both
very
sides
purpose
100
of the
times on this.
procedure
This is like the
to
fifth hearing on
make
the same
something
damn thing. We
private
don't need to keep hearing
is
it.
for the court to rule.
Nobody's
going to
make a better argument at any given time.
Considered a public filing. So that procedure was followed here. It was not followed in Algier. He put the documents into the public domain. The second thing is,
Thank you, Tammy.
I think strains credibility to say that the factual record in Algier is in any way comparable to the extent and nature of pretrial publicity in this case. We're not dealing with a confession letter by a jailhouse informant, a single letter by a jailhouse informant. You can't compare the President of the United States, the Vice President, the Governor, to a jailhouse informant in terms of the weight that the public is likely to give to that information. So the court in Algier was not saying, we don't care what the pretrial publicity is. We're holding that in every case where there's been any disclosure of information, no matter what it is, that's the end of the ballgame, and the court has no obligation to try and restrict further prejudicial pretrial information. The court never said that. And when Mr. Ballard says he can't imagine any more prejudicial information than a letter from a jailhouse informant, I would recommend to him the facts of this case, because this is a case that goes way beyond a single letter from a jailhouse informant. It covers opinions by highly respected, in this county anyway, public officials who directly state that Mr. Robinson is guilty and deserves the death penalty. And Mr. Ballard says Rule 3.6 has no relevance here. It has relevance to the extent that it defines what prejudicial pretrial publicity is. It defines what the categories are. And the Levitt decision, which is cited in our motion by the recent decision by the Utah Supreme Court, emphasizes that the categories outlined in the commentary of Section 3.6 identify what those categories of prejudicial pretrial publicity are. And it's not, again, unlike Algier, we're not talking about a single instance. We're talking about repeated exposure to the most prejudicial information that is imaginable. And what will come out of today's hearing will be more of the same. In other words, right now, as we're talking, there are media talking heads, law school professors, criminal defense lawyers who are being paid for their opinions and not disclosing that they're being paid for their opinions, who will say things like, oh, this motion by the defense is absolutely frivolous, or this motion is wrong, or this is why this motion should be denied by the court, or characterizing Mr. Robinson's demeanor, et cetera. So this case is not comparable in any way to Algier, and the court should not buy into the notion that they are comparable. The idea that we're mixing the standards, I think, could be bounced back to their side, because they say, oh, the standard for closure of a hearing is, compelling state interest and no reasonable alternatives. But they skip a step, which is this type of a hearing that we're seeking to close, the portions of which will discuss the prejudicial pretrial publicity, is that subject to a First Amendment right of access? We haven't waived that argument. That's an argument that Kern says should be at the forefront of the court's analysis, regardless of which side is raising the issue. The court has to determine whether this hearing on the 17th is comparable to a trial or to a prelude. It's unique in the sense that it's focused solely on what everybody has to say is inadmissible evidence. Is that the type of procedure that there should be a compelling interest demonstrated? And in any event, we have demonstrated a compelling interest. Mr. Robinson's right to a fair trial by an impartial and representative jury. And that right, according to the U.S. Supreme Court, takes precedence over every other right. The press enterprise case that was cited about the efficacy of voir dire and the Algier case that was cited for the same proposition conflicts with Gentile versus Board of the State Bar, which was decided years after Press Enterprise 2. Press Enterprise 2 is decided in 86. Gentile's decided in 91. And if you look in the discussion in Algier about what cases are cited when the court talks about the efficacy of voir dire, Gentile is nowhere mentioned. So the Supreme Court may have its own view, the Utah Supreme Court may have its own views about the efficacy of voir dire, but I would ask, how does one explore with a juror whether they have been exposed to publicity that is specifically prejudicial, things like a confession? Do you bring, well, did you see any, have you read, you ask a juror, have you read or seen anything in the electronic media about this case? Not that I recall, is a typical answer, even if they've seen a lot. And then the next question was, when you attempt, can you, or should you attempt to jog their memory by mentioning specific prejudicial information? Well, how about a confession? How about a statement by the President of the United States that Mr. Robinson should be executed? Have you seen anything like that? Now, that type of voir dire is designed to bring to the jury's attention the very information you don't want them to have. So, just throwing out the vague proposition that, oh, voir dire, the traditional means of curing pretrial prejudice, doesn't deal with the realities of voir dire in a capital case where the prejudicial publicity is as extensive as this one. There is a discussion of this issue in an older case, but it always struck me as kind of really stating the truth of it. In the court, this is an old, high publicity murder case, California case, Corona versus Superior Court, 24 Calap 3rd, 872. And the court is characterizing its experience with voir dire as an effective method. And the court says, questioning on voir dire as to the effect of the media's evidentiary disclosures, one prospective juror may deny or admit awareness, another disclaim or admit prejudgment. One may falsely deny both knowledge and prejudice for the sake of a place on the jury. An honest juror may admit knowledge or tentative prejudgment and find himself excluded. Many will sincerely try to set aside their preconceptions and give assurances of impartiality, yet unconsciously bend to the influence of initial impressions gained from the news media. And along the same lines, we have in this case an expert declaration that is discussed in docket 305, which talks about the importance of repetition in causing conscious and unconscious bias in jurors. And the importance of unconscious bias is it's by definition bias that cannot be weeded out by voir dire because the juror doesn't know they've been affected by it. And the expert, this is page 94 of 305, says, the volume of coverage in notorious cases can be overwhelming. And studies show that the quantity of pretrial publicity to which jurors are exposed affects their level of bias. Across studies extending back several decades, researchers have demonstrated that individuals exhibit a greater propensity to prejudge defendants when they are exposed to more publicity, both as a general conclusion, i.e. showing a general propensity to prejudgment based on an increase in the amount of exposure, and in response to specific thresholds, i.e. showing that prospective jurors exposed to at least 3 newspaper articles about a crime were more likely to believe there was ample evidence against the defendant. This effect has been demonstrated in both naturally occurring and controlled settings, confirming the validity of the proposition. And along the same lines, the U.S. Supreme Court, in a case cited on that same page, U.S. Department of Justice versus Reporters Committee for Freedom of the Press, 489 U.S. 749, says, the fact that an event is not wholly private does not mean that an individual has no interest in limiting disclosure or dissemination of that information. So the fact that there's already existing prejudicial pretrial publicity out there should not give rise to the conclusion that, oh, well, let's add some more. Because the court at this stage of the process still has the ability to control this process in a way that will protect Mr. Robinson's right to a fair and impartial jury by a representative jury. And just to say, well, we'll handle it down the road is to ignore the mandate of Maxwell that the court has to be proactive and to take action before the prejudice happens. So we're seeking to prevent future prejudice. It's already existing, there's no doubt about that. But to throw your hands up at this point, this early stage of the case, and say there's nothing I can do about it, we're just going to continue along the same lines, allow these people to keep making these prejudicial statements and hope for the best down the line, and that we won't have to exhaust the entire pool, we won't have to move for a change of venue. And again, there are costs associated with those remedies that we think argues in favor of this motion.
Thank you, Mr. Burt.
Thank you.
All right, I just have a couple of questions for the parties. The intent is to obtain these, and then the court will take a brief recess. I want to discuss issue its ruling, and I want to update my notes. I've been taking notes the whole time. I'll be issuing a ruling, but I also, based off that ruling, will want to talk about what the expectation for the next hearing is, to set the guidelines in place so we all come in.
Meaning he's already
knowing,
decided.
what the expectation is and what we'll be handling specifically. All right, to the defense, most pretrial motions discuss evidence that has not yet been ruled admissible. If the court seals the January 9th motion simply because the evidence might be deemed inadmissible later, wouldn't that set a precedent requiring the court to seal almost all pretrial evidentiary filings?
I think it would depend on the nature of the evidence. In other words, if it's evidence that doesn't go to the heart of the case, the court always has to consider the nature of the evidence. Right. Here we're talking about essential forensic testing opinion evidence. And so that puts it into a category that I think is distinct from any and all motions having to do with any sort of evidence. There may be some evidence that doesn't fall into that category. And I note that on this precise issue the court raises, the sentence in Kern's Tribute addresses that. The court says, if the prosecution elected to try to use such evidence in the preliminary hearing, in advance of a ruling on whether it should be suppressed, the defendant could seek special measures to avoid its public disclosure. So I read that as saying the court is not really focused on whether there has been a ruling on admissibility. It's again, what is the nature of the evidence? Why are you trying to disclose it? And I think the court can make reasonable distinctions between, is this the kind of evidence that could cause problems, or is it, in the harmless error category?
Thank you, Mr. Burt.
Sure.
In offering the opportunity, do the other parties wish to respond to that question? You don't have to, but if you want to, I certainly want to give you that opportunity.
No, Your Honor, thank you.
All right.
I'll just respond, Your Honor.
All right.
Marissa Urask on behalf of the news media again. So just to respond to the sort of the argument that the test should be whether the evidence goes to the heart of the case, that's not really a standard that I'm aware of in case law or the rules. Again, the court goes through the balancing test, and there has to be, specific findings. There could be a substantial probability of prejudice. And here I would just argue that's just not the case. And I will just direct the court to the arguments we made in our sealed supplemental opposition that is very specific to this motion as to why that showing has not been made here.
Thank you. All right, to defense, you noted if full classification is denied, you would seek to file redacted versions. Have you prepared a proposed redacted version of these motions? And do you believe redacting the specific evidentiary exhibits and media links would sufficiently cure your constitutional concerns?
We haven't yet prepared those redactions, but it's easily done because it focuses on the factual portion of the motion. So essentially, it would be submitted to the court the legal arguments, absent the factual basis that's discussed in the statement of facts, and later referenced in regard to the criteria under the rule, some of the publicity set forth there as well. So it can be easily done. It would satisfy the concern insofar as the motion goes. What you would lose in that, I think, is at the hearing itself, having the court have the ability to actually listen to the evidence. I'm not sure, I think that falls into a different category. In other words, the motion is one thing, but presenting it live to the court, I think presents a different issue. And perhaps that can be addressed by submitting to the court in camera the clips that are outlined in the motion, which that would satisfy our concern. But the only other thing I think could arise is if experts are commenting on something the court has considered in camera, those opinions might disclose that information. So that could be a special problem. But in general, I think redacting the motions and providing the court with a disk or a thumb drive that contained the clips with the understanding that that would not be disclosed. In other words, by providing that to the court, the media would say, oh, you provided to the court, therefore it's filed and we're entitled to it. I think the understanding would have to be the court is being provided this with the understanding it is private. And to answer the court's question, I think those kind of remedies would resolve the issue.
Thank you, Mr. Birch.
Sure.
All right, turning to the state, the defendant argues that publicly filing the motion to exclude forces them to republish prejudicial media links and private information protected by grandma, effectively doing the media's work for them. Does the state acknowledge any risk to the integrity of the proceedings by hosting a consolidated repository of this potential prejudicial material on the public docket?
I think, defendant, you can't ignore the fact that there is a risk that when you repeat something, it's emphasized. Certainly we agree with that there's a risk of that. I think Allgaier is controlling, though, where it says the fact that something is already public tends to support that should remain public, and that Allgaier it didn't directly address whether that would risk republication, whether the republication would risk emphasizing, but certainly that's the undertone there in Allgaier. And I just wanted to clarify one point there. If you look at paragraph, just let me grab my computer.
Sure.
If you look at paragraph 16 of Allgaier, this is about the point that Mr. Burt made that defense counsel in Allgaier actually attached the letter to his public brief in the Supreme Court. That was not the decisive factor in Allgaier. All that did was give the court even greater confidence that affirming the district court's ruling to release the letter was correct. If you look at paragraph 16 in Allgaier, about halfway through the paragraph, it says, the district court considered the specific language within the Cobb letter. Cobb is the name of the inmate. The specific language within the Cobb letter and its potential impact on Mr. Allgaier's right to a fair trial. But the district court concluded that given the amount and type of prejudicial information already in the public domain at the time of its decision, unsealing the Cobb letter would not undermine Mr. Allgaier's right to a fair trial. So the district court's decision was based on what was already in the public, the information that was already public when the letter came before the court. The letter at that time was still sealed. And then the Supreme Court does not say, it doesn't question whether that balancing was correct or not. It says we are
Anybody still there? I got disconnected, or my power went out. I'm just going to see if it's working. Oh, cool. Yeah, the power went out. And then, and then I just connected to my backup. That's back on again. I didn't, my computers and everything didn't turn off, but the lights turned off. And that was pretty crazy. I think I'm back on. Am I here? I don't know. Let's see. Testing 1, 2. Somebody sent in a super chat. Let's check. Let's check. Yeah, well, I guess they just went out for a break anyways. So.
So the
Here's where it
decision
stopped,
in Allgaier
basically.
was based on the information that was already in the public domain, even absent the defendant attacking.
Yeah, send in a super chat really quick. Let's see if it works.
All right, thank you.
Plus, we need the support for the
Has no
channel.
further
It just was
questions.
dead as a doornail during that
We're
2 hours.
Right at the noon hour, the court intends to take a 15-minute recess to review my
15
notes,
minutes.
considering the argument.
Okay. So this is the 15 minutes. All right, let's go. Let's check them out. Test them out. Well, either way, you guys, if you're able to help support the channel, that would be great. We've been on here for 2 hours and 17 minutes. Other than one really large one, we haven't really done very well. So if you have the ability to help support the channel, that allows us to do more of these in the future, that would be great. Thank you. Plus, if you like what I do, how I cover the cases. Yeah, this one's... I don't know. If you haven't seen my videos and how it's all put together, and there's nothing made up in them at all, it's just, then you just don't understand. It's like if you're following Candace Owens, wondering about the Egyptian plains, and you haven't followed what we've done over here, then there's just something wrong with you. That's it. There's no way, no two ways about it. All right, don't get all started at once. Yeah, so Tyler Robinson, he goes through this tunnel at probably 11:53-ish, and there's there's footage of him going into the tunnel. Then there's footage of him going up the stairs over here, but there's still frames from footage. Then after he comes up the stairs, comes out, he walks down this direction. And then he cuts up, walks up the path over here, and then right around 12 or so, 12:02, he's probably spotted walking right in this area. Then he goes inside, and he's limping. And then he goes up these stairs right here onto the roof, and you're right there. It's the easiest thing in the world. Then you hop over this area here, and he laid down behind this wall and put together the rifle that he had down his pants with a screwdriver. It's just like 2 bolts. Put it together. And then he ran over to here, and then at right around 12:23 and 28 seconds, he fired a shot from right there that hit Charlie Kirk. Then he got up, ran this direction. 12:23:34, we see him on surveillance run across. Then he hops down onto the grass right here. You see the rifle in his hand, wrapped in a towel, jumps, hits the ground. Then he keeps, sort of fiddling with the rifle as he's moving around across the grass here. And then in this position, he goes across the street and into the woods. Now a camera right up here at the top, right in this position. You can literally see the camera, this little white thing here. That camera is filming the whole thing. It's a 360-degree camera. All right. So it sees him running across. I actually flew a drone up in the air and put it right there, and we know with the 360-degree camera, so we know exactly what it looked like. Then he went into the woods over here. He ditched the rifle. He put it in there. Then he left. And he changed clothes, put his maroon shirt on, ran over here, went over there, and left. Then later on, he tried to come back and get the rifle, but he couldn't get in there because police were blocking the roads. And they got the rifle. The parents, when they put the photographs out, said that the person going into the tunnel right here looked exactly like their kid. And then they tried to get a hold of him, and he wouldn't respond. And then, one time, when his mom asked, he said he wasn't feeling well, so he stayed at home or something on a certain day. And he confessed to his parents. He wrote about what was written on the bullets in messages. I mean, it couldn't be any worse for this guy. I mean, I can go through the whole damn thing. Couldn't get any worse. Hey, wow, thanks so much, Virgo Alex and Tammy McDonald. I guess it does work. The super chats work. Whew, wow, unbelievable. Yeah, I've literally, I think if people watched my videos, you couldn't have a stronger case, and none of it's made up. See, Candace Owens, that's all she does, is make up stuff that people go, ooh, 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 because their brains are weak. It doesn't take skill to invent a story. Well, I guess her elaborate stories might take a little bit of imagination. But it's easy to make something up. I could just sit here right now and just come up with just some random theory, and, the suckers out there would believe it. And unfortunately, it's not just Candace Owens anymore. The whole industry, there's all these blood-sucking psycho dipshits that are on the coattails of Candace Owens that sort of, they got to sort of agree with her, and then they get the same audience of fanatical nutjobs. Like that one asshole attorney who pretends that Google Trends makes it as real, like a real investigative tool. In this case, it's sick, They have used me before. I mean, years ago, but I don't know. They just get their own people to recreate what I do. I do it in a way, and they go, oh, wow, okay, and then they come up with something similar. Yeah, that's what I was saying. He wrote the notes, and he wrote about what was on the bullets to Twigs, his boyfriend or girlfriend, however the hell you want to refer to it. And then he told his people on Discord that, hey, sorry you guys, and man. And when you read the letters back and forth, it's not even. I mean, maybe some of it was written to help one or the other in their own minds, but it was a real conversation, and I know that because one of the portions in there, the guy got confused of when he said why, because he wrote this long paragraph before that mentioned like 5 or 6 different things, or maybe 4, and he said why, and he says, why did I do it? And then they said, yeah. Why would you put that little segment in a fake, contrived thing? Like, you wouldn't even think of doing that. An error like that. You would just know what you're writing. Dude, bro believes the feds slop? Or is he Hey, listen. I work for the feds, okay, the demon? I work for the feds. I work for the FBI. I'm out here to peddle the feds and state narrative. Okay, that's what I do. That's what they pay me to do. I'm waiting for my first check, however. Israel's given me 7,000 a video, of course, so we've got to just keep on working on those. They give me 7,000 a video. That's why I have to ask every show 1,400 times for a nickel or for a dollar. You guys are so stupid, okay? Bro believes the Fed slop, or is he disinformation? Ooh. Wow. I believe the sheriff's and the investigators' information. And not only that, the information that we've seen absolutely verifies all that stuff. God, these people are dumb. They think they're being really edgy and cool to think Tyler Robinson didn't do it. Just like the same people who think Richard Allen didn't do it, Brian Koberger didn't do it. They think they're really cool. Yeah, we're just so interesting. All right, let's see. Here we're back now. Instantly defensive, case closed. Ooh. Shut the hell up, man. You're a joke. Jesus. Yeah, I've only heard that 1,000,000 times. It's a joke over here. Every case I cover, I work for the feds. You're no different than the rest of them, you idiot. That's why when you say defensive, that's not really defensive. I'm just joking around with your idiocy. Kanika Jenkins. Oh, he's the guy behind the desk. He's the 911 caller. He works for the feds. He's a bald-headed billionaire. Well, I'm not bald-headed. That's why I had to put my face out there. I mean, you realize how idiotic you sound, right, the demon? Seriously. Do you understand that? I mean, you actually are a stupid person. You know how I know that? Because I'm me, and I know I don't work for the feds, nor am I a disinformation person. I just put together the facts of the case. I have a brain that works. Yours doesn't. Go do something else. God, what an idiot. Jesus. Unbelievable. Whew. Wow. Scary almost. So I thought I saw the judge sitting down a minute ago. I have a higher IQ than you, Gray. What did you get on your SAT test, you bastard? Whatever you got, I got 1 point better. Let's put it that way. Total name calling classy. Ooh. You mean like a minute ago how you said I work for the feds? I'm a fed, that I'm a... there's always these passive-aggressive dipshits that show up here. You know, they just come on, they make their little comments. They don't remember what they just said 5 minutes before. That I work for the feds or I'm a disinformation person. That's name calling. Okay, did you forget that part? I'm just choosing to directly call you an idiot. And you know how I know that? I'm in a unique position to know you're an idiot. You know how? Why? Because I'm me, and I know I don't work for the feds, and I know I don't put out disinformation. I just put out the facts of the cases. So I'm sorry for your ignorance. Go do something else. If you can't be here and just look at the facts of the case, then get the hell out of here. If you want to listen to Candace Owens, that means you're dumb. Yep, we're doing it. Did say you worked? Did say you... Can you type a better sentence? What kind of a dumb... Did say you worked for feds? Oh, you mean when I was going around going, yeah, that's right, everybody. I work for the feds. I work for the CIA and the ops. Oh, yeah, the Israeli government. They sent me 7,000 a video. You're so stupid. Oh, I believed it, though, Gray, when you said it. I got it recorded. God. Where do these people come from? You got about 5 more seconds, and I'm going to remove you from the channel permanently. All right? It was a joke. If your brain worked, you would have understood it. But you're like Candace Owens. Your brain works the same, like a moron. What an honor. Ooh, ooh. Get out of here. Oh, Jesus. Man. You're going to be proven incredibly wrong. You're an embarrassment. Get the hell out. All right. Sniveling dip crap conspiracy whack jobs. I mean, just. Sorry for cussing so much, you guys, but that's just the way it is. So if you want to help support the channel, and that would be great. You know, we lost about, I don't know how many people were here before, but a lot of people left because I got disconnected for less than a minute. You know, they can't wait. All right, here we go.
Thank you for the patience of the parties. This court has considered the oral arguments made today and has considered the briefing, which has been previously
I was probably really
submitted.
loud because I forgot to turn it down.
The parties for their diligence, their arguments, as well as the quality of briefing that was done on this issue. And so the court is going to issue its ruling on what is requested and what is before the court. Before the court are three motions to classify court records. Defendant's motion to classify as private motion filed January 9th with exhibits. Defendant's, which is docket 285. Defendant's motion to classify motion to exclude, docket 310. And defendant's motion to classify reply in support of motion to exclude, docket 400. The public has a presumptive right to access court records. Open court records assist in educating the public about the workings of government and the decisions being made on the public's behalf. Contribute to the informed debate, allow the public to hold public officers and employees accountable, increase public confidence, and provide material for independent research on improving government policy. The right of access, however, is not absolute, as cited to in Algier. Other factors may favor closure of the records, such as protecting personal privacy, non-parties participating in the court proceedings, and the defendant's right to a fair trial. A court may consider any relevant factor, interest, or policy in both in favor of and opposition to closure in determining whether to classify or close all or part of a court record. In making its determination, a court must make findings and conclusions about specific court records, identify and balance the interests favoring opening and closing the record, and, if the record is ordered closed, determine that there are no reasonable alternatives to closure sufficient to protect the interests favoring closure. With this legal framework in mind, the court now turns to the pending motions to classify. And as it relates to defendant's motion to classify as private motion filed January 9th with exhibits docket 285. Defendant seeks to classify a motion filed on January 9th, 2026 as private because it addresses evidence that has not yet been found to be admissible, and it is of a nature that could easily taint potential jurors. If the court denies his motion to classify, defendant requests an opportunity to file a public version of the motion that redacts the attached exhibits and details from the exhibit discussed in the motion. Defendant does not provide any specificity explaining why the potential evidence discussed in the underlying motion is of such nature that its disclosure could taint the jury pool. The potential evidence discussed in the motion is technical and discusses the process of scientific and forensic testing of physical evidence. It does not contain any obvious private or inflammatory information. And while the evidence has not been admitted at trial, there is no pending motion to exclude it. In balance, defendant has not provided a sufficient basis for the court to find that the interests favoring closure outweigh the interests favoring an open proceeding and the presumptive right to access. Moreover, as the Utah Supreme Court recognized, even in highly publicized cases, a defendant's right to a fair trial can be protected through the regular, time-honored process for selecting jurors, like enlarging the veneer of potential jurors, utilizing a detailed juror questionnaire, and conducting a thorough voir dire of potential jurors. Defendant's request to classify the motion filed on January 9th, 2026 is respectfully denied. As it relates to the motion to classify motion to exclude, docket 310, defendant seeks to classify his motion to exclude cameras from the courtroom because the motion compiles a litany of unfairly prejudicial and oftentimes inaccurate electronic media interviews, comments, and photographs. Furthermore, the motion references court filings that are classified as private and references the publication of private information of individuals involved in this case, allegedly in violation of law. Defendant does not provide any citations to the underlying motion to aid the court in identifying the potentially private information. The court is sensitive to the amount of pretrial publicity generated by this case, including an extensive amount of public commentary and inaccurate or conspiratorial descriptions of alleged evidence supporting or negating defendant's guilt. A substantial amount of this pretrial publicity is organized and memorialized into defendant's motion. Because the references to pretrial publicity are, by their very nature, already contained in the public arena, interests favoring closure are greatly diminished. And this citing to State v. Algier. The public already has access to the majority of the information contained in the motion. Upon balancing the interests at play, the court determines that defendant has not shown that the interests favoring closure outweigh the interests favoring access to the record, with the exception of the potentially private information referenced in the motion to classify. The court orders defendant to file a version of his motion to exclude cameras, referencing docket 305, that redacts private information referenced but not specifically cited in his motion to classify. The redacted versions of the motion to exclude cameras must be filed with the court by the end of business on March 30th, 2026. If no redacted motion is filed by that time, the court will reclassify docket 305 as public. If a redacted motion is filed, the court will maintain the private classification on docket 305. Accordingly, defendant's motion is granted in part and denied in part. Finally, turning to the defendant's motion to classify, reply, docket 400. Defendant seeks to classify as private his reply memorandum in support of his motion to exclude cameras from the courtroom. Defendant argues that his reply memorandum should be private because it references portions of the motion to exclude cameras, which he has also moved to classify as discussed in the ruling on docket 310. Defendant does not cite any part of the reply memorandum that references potentially prejudicial information in the motion to exclude. Based on the record before it, the court concludes that defendant has not provided a sufficient basis for the court to find the interests favoring closure outweigh interests favoring access to the reply memorandum. As such, defendant's motion is respectfully denied. I will go ahead and sign this order, and it will go into the record. With this in mind, counsel, how would we like to proceed? What I want to turn to next is this upcoming April 17th hearing, how it will be conducted, and so we all have a good idea of what to expect and to prepare for. And so first, I'll hear from defense in regards to your expectations on moving forward, given the ruling of this court, and then I'll turn to the state as well. All right, Mr. Burt.
So, Your Honor, we anticipate calling several witnesses. One witness would be in the nature of a foundational witness who would summarize for the court the nature and extent of the publicity. Would be testifying to certain things like publication, scope, number of times certain articles have been referenced. We would be playing for the court the various clips that are referenced in the motion as well as others not referenced to provide the court with an overview of what we think the court needs to look at in terms of the nature and extent of the publicity. Then we would also be producing a expert witness whose declaration has already been provided to the court and to the parties. And that expert would testify to the facts and opinions outlined in the declaration that is attached to document number 305. We'd also have a third witness potentially who would be testifying to laying a foundation and testifying about a public opinion survey that is in progress right now. And that would be the extent of our evidence.
All right, thank you, Mr. Birch.
Sure.
To the state.
Thank you, Your Honor. Chad Grunander for the state. I would anticipate that the state would be calling one witness, and it would be in the nature of a foundational witness to just talk about the nature and the extent of publicity that is negative towards the prosecution and or negative toward Mrs. Kirk. And I believe that would be the extent of the evidence that would be presented from the state's side.
Thank you. All right, any other input from other parties?
Your Honor, the media does intend to be there, but we don't intend to try to complicate matters. We'll be there to make argument, as would be helpful to the court and to protect the interests that media believes may not be addressed in the other argument, but we will sit on the side table there as well.
All right, thank you. Thank you to all parties. I appreciate that information. Given the detailed motion filed January 9th, the court will read and prepare as it already has for that, and so the court finds it unnecessary to present all that evidence verbatim. The court does not need to see the video clips, and if defense wishes to give summaries of what's in the motion, the court allowed the overlength memo to be filed with the intent of allowing you that ability to put in detail what you want to be considered and include your argument. And so the court accepts that and receives that and will review it thoroughly. But for the benefit of this hearing coming up, the court does not feel it is necessary to replay what is listed in the motion. Again, if you wish to give summaries of that, I understand that's going to your argument, but to go through it all again as detailed in the memorandum is not necessary for the finder of fact, the court. And so I will, that is one of the guidances I wish to give. In regards to the witnesses, that is fine. What I would ask is that your witnesses be succinct, on point, and let's stay focused on the issues that are before us. My fear is that we start veering in other areas that are not germane to the issue that's before the court. And this goes for both parties. I'm looking at Mr. Burt, but I equally am considering the state as well, because you indicated you're calling a witness. And so I ask that you prepare that witness to stay on point and to focus on the main issues that is before this court. We are scheduled, I believe it is April 17th at 10 a.m. And so we do have the remainder of the day.
I guess we'll do that one too.
That being said, just because it's there doesn't mean it needs to be used. I want us to be focused and addressing. I also wish to encourage the parties to give your argument the weight that it deserves. This is an important issue, and I encourage both parties to be fully prepared and argue it. This is an important issue. I recognize it for both Mr. Robinson, for the state, for victim representatives, and for the issues of open and transparent courts. So the court is prepared and will be prepared at that hearing to hear the arguments. And I anticipate, unlike today, I will not be issuing a ruling on that day. I believe that what will be argued, the court needs to let it percolate, to examine, re-examine the motions, re-examine the notes, to ensure that the ruling the court makes properly balances the constitutional rights of Mr. Robinson, Ms. Kirk, and the concepts of open and transparent courts. With that in mind, counsel, is there any other issues that we need to address? Mr. Burt.
Your Honor, two questions. We had anticipated filing with the court either a disk or a thumb drive that contained all the reference electronic media cited in the motion. I assume from what the court said, the court has no objection to that.
No. And, well, to the state, any input on this request from defense? All right. Mr. Grunander is submitting on it. So I'll accept that and I'll receive that to review, just to ensure, because sometimes URLs change, and so I appreciate you providing that so the court has a single place to refer to.
Sure. The second issue, Your Honor, I came across when I was preparing for the hearing today a letter brief that is online, dated October 28, 2025, from a group called Human Events. And it's addressed to Your Honor, and it's in the nature of a brief on the closure issues we've been discussing today. It indicates at the bottom that it was CC'd to the parties, but discussing with the prosecution, neither party has actually received this. I was curious as to how the court handles, if it does, letters of this nature where people are, unbeknownst to the parties, providing opinions, and in this case, legal briefs to the court, which I assume the court is not looking at, but I wondered, what is it? We don't see this filed in the docket.
Right, so that would be ex parte communications.
Right.
And the court has not reviewed that. Do we have a record of that? All right. What is the request of the parties? We have a record of it. I haven't reviewed it. It wouldn't be proper for me to do so, so I have not. What is your request as it relates to that particular brief?
As long as that's the court's ruling, that was our concern.
Okay.
And just to make clear that that in fact is the rule, is what we were after.
All right, thank you, Mr. Bird. I
Thank you.
appreciate you addressing that.
Sure.
To the state, any final issues?
Just briefly, Judge, there has been discussion today about the status of the April 17th hearing itself, whether it will be open or closed or portions of it. I'm assuming that that'll be addressed first thing on April 17th?
It will. I wanted to see if the defense wishes to file that motion in private that the court referenced in its order, and then I'll take it from there to see if there is private personal information that is anticipated being argued. And so I want to make sure that that's fully vetted out, that the parties see, and that we can prepare. I don't want to simply say it is, the presumption is it will be open, but could there be a portion that's closed? Absolutely. I just don't want to state how much or how long, because I don't know what the depth of that information. So I want to review that, but the anticipation is it will be an open hearing. And again, if there is a portion that dictates that closure is appropriate after balancing all the factors, then there will be a closed portion. Thank you, Mr. Commander.
Thank you, Judge. And then lastly, Mr. Novak did forecast a motion with respect to the preliminary hearing. So I don't know if we're going to discuss that further today. So
that's right, Mr. Novak. You talked about that. I said we would revisit it. At this point, what I anticipate is let's go ahead and brief that so it's fully briefed. Right now, it seems a bit premature because I'm not sure when that information is going to be passed over to the other side, how that affects how it's processed and reviewed. And so I'm happy to set a briefing schedule. It sounds like both parties are aware that the scope of what discovery could be coming over, but may not know all the details because it hasn't been passed over. Mr. Novak.
So that's fine. We're happy to brief it, and I think we should, in the time permitting, set a schedule so that
Absolutely.
the court can rule on that before its schedule gets worse. What counsel for the state told us yesterday is that they hope to receive certain materials in the next week or so. We also received yesterday, separate from the forensic sciences, a hard drive that has the images of all of the seized devices.
Okay.
At least one piece of evidence that I think that the state wants to present at the prelim is somewhere in one of those devices in theory. The state may have another way to present some of that evidence, but we don't know yet. So that's like an additional piece of that. And we, of course, haven't opened that box. We haven't sent it to the right expert. We do know that once we get all of the ATF case file materials from their forensic work and the ATF and FBI data files that we don't have from their forensic work, that it's not just about counsel receiving this, obviously, Your Honor. There's nothing that we can do, for example, with proprietary scientific data that has to be run through software that our experts have access to. So it's not like, oh, we got some information, we're ready to go. That's just what if I didn't adequately express that this morning, I wanted to do that. So we can brief it. It sounds like it should start with Mr. Robinson's motion to continue. And I guess the question is, working backwards, when does the court want to hear that motion?
Well, I certainly want to address it before the preliminary hearing itself, right?
Sure.
That would be appropriate. Well, how quickly could you have that motion filed? I guess that gets the train on the track.
I think it could be fully briefed if everybody is cooperative about that, so that it's ready for submission before April 17th.
All right.
Okay.
All right. So
I mean, that's basically a month and a couple days to brief a important but discrete issue.
Of course. And so is that, how much time would the state need to respond?
We could do it in a week.
All right.
I know the rules allow 2 weeks, but with the truncated schedule, we can do it in a week.
So the 24th of April, that would be the preceding Friday. So,
I was suggesting, if I may, that we would fully brief it so that when we are here in person with Your Honor on April 17th, the court can hear argument if necessary and issue a ruling.
so are you saying your motion as well as the other side, or what's, I want to make sure I
Yeah, I'm
understand.
saying that we can file our motion. Let's just say we need 10 days from now, or maybe
Okay, I see.
2 weeks to file the motion. And the state's saying they have a week. Maybe we have a few days for a reply as necessary, and it's submitted sufficiently in advance of April 17th, since we'll be here on that day, for the court to actually hold a hearing on the motion to continue.
I see what you're saying.
Does that still make sense to everybody?
So for clarity, you'll have your motion filed within 2 weeks, which is March 27th. And then state can have its reply by April 10th, and I think that's what Mr. McBride was alluding to. And then on that April 17th, the court will be prepared to hear argument on that as well.
I think Mr. McBride said they need a week. We want to file a reply, although we won't need a week to do a reply.
Okay, so I see. So from the 10th to the 17th, if you wish to file your reply of April.
Our response, April 3rd.
Okay.
1 week from the 27th.
And then by the 10th?
Definitely.
All right.
So it's the 27th, the 3rd, and the 10th.
That's correct. I appreciate the parties working together to
That was actually
flesh that
kind of
out,
cool
to
how they
address that. And then as it
worked all
relates
that
to the
together.
April 17th hearing, that will be an additional issue that we address as well. And we do have the benefit of the day, so we can proceed accordingly. Anything further?
No.
Not from the state, no.
All right. And to defense, I'm anticipating Mr. Robinson will be here in person for that hearing.
Definitely.
All right. Thank you. All right, counsel, I appreciate your
So I
hard
guess he
work
wasn't
today
there
and your
today.
arguments, and we have a good path moving forward, and we'll address the issues on April 17th, and I'll look for those briefing on the 27th of March, 3rd of April, and 10th of April as well. With that in mind, court is now in recess.
All right, so who's going to tip the channel for 3 hours of streaming right here? Yeah, well, I think the judge is good. He's not, I mean, he doesn't cave in. You know, he literally, like Judge Gould, just like, we're not going to have it. Can't be streamed, can't be this, can't be that, can't be this. This guy, he's really open, wants the public to get the information. Anyways, thank you to Paul Ayers and Tony Morrow and Laura Denema. I think I said it right the first time. Laura Denema. Old Grandma, KMTX, Tammy McDonald, and Bakalula gifted 20 channel memberships. And Alley Cake, Whiskey Boots, Old Grandma, Paul Ayers, Whiskey Boots, Blenderella, Karen, Tammy McDonald, Violet, USMC Mom, Labrador Mom, Lisa Valenzuela, Virgo Alex gifted 5, Tammy McDonald, and Ilra, let's see, Il Rajim. Is that right? Il Rajim? Now, I used to like Candace Owens too. But right now, she's an absolute embarrassment. And people who defend her are just as big as an embarrassment. They just don't realize it. Candace Owens is not telling people the truth, nor has she put together anything. Oh, she's really on to something. Oh, she's on to something. She's not on to anything. She is a joke. Financially, she's doing incredibly well. Okay. But that's not because she did anything worthwhile. She is absolutely using millions of people, playing to their desire for everything to be more complicated and more intriguing. The Tyler Robinson case is sort of boring in reality. Very simple, very obvious. A guy who is dating, he was a conservative at one point, I guess, and then he realized he was attracted to other guys, and then he's dating a transgender person, and then he wanted to be a hero, because Charlie Kirk is like, was anti-transgender in sports, probably just in general, really. Not the people, just the concept of it. And then Tyler Robinson found out that Charlie Kirk was going to be giving a speech on the campus, figured out the day, went there a week or so before, scattered it out, walked around, and then on that day he drove over there early, drove around again, scattered it out, did a dry run, like at 10 something, walks through the whole thing wearing a maroon shirt, then leaves, comes back later with darker clothing on, backpack that had extra clothing in it, a towel. He had the rifle down his pants, and he was limping. He walked. I went there myself. It's the easiest damn thing to do in the world. You just walk through the campus. You literally walk into this building right over here. You walk straight across outside. Then you go outside. Then you take a left, and you just walk right up these stairs. And when you get to the top of the stairs, you literally could walk right to there. They have a fence here now, but you could walk right to there. And then from here, he just stepped over this fence, and then he ran over there at 12:23 and shot Charlie Kirk. And then he left. He ran across the grass over here, jumped off the roof, and then he took the rifle out of his pants, put him into the woods, then changed clothes, and then he left there. He left it there. And then he tried to retrieve it, and he wasn't able to retrieve it, so he started writing notes to Twiggs saying, oh, man, I'm screwed, and I don't know. You guys, it's just the most simplest case in the history of mankind. His parents recognized him in there. He is actually proven to be there. Candace Owens accidentally prove that he's literally in town, showing him at the Dairy Queen. So you know he's there. Plus he said he was there, you know, in his messages. And he even mentioned what was written on the bullets, for God's sakes. Anyways, I'm going to get going. Thanks, everybody. See you later. Have a good one. Be safe out there. We'll do the next one on April 17th. Yeah, I've been doing this true crime thing for quite a while now. And during this whole time, I have not seen one person that is a crime dissector. Rejector, I'm a certified human lie detector. Gonna get ya on a stretcher if you try and play me like an old projector. Crime sector is my nectar. Professor Grego's gonna give another lecture. Crime collector, freak connector, and I'm always gonna be a pup protector. Fool deflector, interceptor, and I'm meaner than a spectre with a vector on his spectre. With all respect, y'all. Just remember, I've a total fucking check. I have no agenda, I'm no pretender, and I'll serve it to you straight without the blender. And in the end, I'm gonna send ya on a mission to reveal the true offender. Yeah, so I'll just. All right, that's how loud it's supposed to be. All right, I guess I bet that was. I think I was just really loud, and that was loud because I forgot to reduce it to 22 decibels that I raised it. So sorry about that. Must have been really loud. Probably blew out your ears there. Anyways, thanks everybody. See you later. Thank you for watching Gray Hughes Investigates on YouTube, where we cover true crime using logic, reason, and common sense. Thank you very much for watching, and until next time, be safe out there.